Peace to all the gods and goddesses. Back again with the vibes of the divine. I am the god Shango, and today, get ready to take another deep dive into this electrifying world of the Young Thug Rico trial. Let's get into it, family.
At this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of, that the defense still does not know of?
These nuts. Got him.
Anything that had to do with that drive-by shooting, all right? So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love. I think we're all in agreement
I just
on
got
that.
an email, Your Honor, which has Brady material in it. Was just sent to us
I haven't seen it. It didn't.
10 seconds ago.
The truth is that you are a liar.
The whole purpose of Mr. Copeland taking the stand was to impeach him. Mr. Copeland's testimony was not, well, at the time of this ex parte hearing, it's our stance that he was pleading the fifth, and the state was in a position that their key witness, and without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked, and they needed a mistrial. The trial was not going well. The previous witnesses that have testified, it's been again, I know you haven't been here, but, we've had witnesses testify. I don't remember anything that happened in 2013. It's just been a parade of impeachment by inconsistent statements and contradictions. So, and that's another factor that those cases look at is the how the trial's gone so far and the motivations for goading a mistrial. So I believe that those cases provide some insight and some guidance for the court to consider certain factors when we get to that goading question. And that's why I wanted to bring those to the court's attention.
All right, I appreciate it. Thank you. All right, so Mr. Harvey, you're up. I don't think there are any other motions for mistrial proceed. Well, I guess one I'm definitely going to address before you start your presentation, and that is that you assert in your motion that this court, meaning me, taking over this case, has indicated it does not intend on familiarizing itself with the trial proceedings, and I have no idea where you got that from because I certainly never said that.
When we were here last week, and I don't have a transcript of that, and if I've misinterpreted what you said, and perhaps it was in the context of you saying I'm not going to revisit certain motions or I'm not going to go back to hear those, that was in the context that I meant it. And I said it for a specific reason, because some of the motions, as I allege in our motion, Judge Glanville said, well, I'm going to deny your motion, for example, for a severance, for a 105 instruction. At this point, but that does not mean we're not going to get to a point where I would consider that and grant it. So I meant that in the context of you understanding, this court, understanding the cumulative nature of what has happened and how it would factor into your particular decision at the next point in trial. Is that clear?
Yeah, y'all hear that right? We here to have a good time tonight. I'm telling y'all, we got a good one tonight. Y'all gonna be a little mad, keep your temperatures down a little bit. It's gonna get a little spicy tonight, but we got a good show. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Appreciate y'all. OG Cappy, Steph JK, Tia C. Who else up in here? Julie Horn. What up? Kristen Vasquez, Blue Eye Hillbilly. I see you, family. Let's get into it. We got a good one tonight. Let's go, family.
Absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, as soon as she finishes it. You all have, some of you have already pointed out, particular things that while not the official transcript, I can review on YouTube, and I've done that to the extent it has been relevant to these motions. And I also believe that with the very capable defense attorneys in this case, that you all will be able to elucidate for me anything that I might not have been here present for at the point in time when you make a motion that to any extent requires considering the cumulative nature of anything. Okay?
Well, okay, yes, and okay, no. Okay, yes, I understand that the court is going to make what I think to be an impossible effort to catch up to where we are at this particular point. After 9 months or thereabouts, hundreds of witnesses, I appreciate the court's effort, and I understand the genuineness of the court's statements, and I'm going to do it. But you know what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial qua mistrial. I have joined in we've been goaded into it, but now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. I believe you have to be entirely conversant with the record, with the way witnesses have testified, their demeanor, their voice, their actions, all of which may or may not be caught on YouTube. And there are a plethora of cases. There are many cases that say, you know, just reading a dry transcript is insufficient. Every court from the U.S. Supreme Court down has said you can't necessarily make those kinds of judgments based upon a dry transcript. And I believe that to be true. There's a world of difference, and you know this. Every practicing lawyer knows this, that you cannot get the feel of a lawyer. You cannot get the context. You cannot get the understanding of a witness unless you're there to view that witness. So
Yo, I gotta try that one. Shout out to the fam. Is your name Bahira Ra-Esabe? I don't know. I just had to try it. Bahira Ra-Esabe. Let me know how far off I am. Hey, Shot Diggy in the chat. What up, family? Appreciate you, fam.
I start from the premise that no matter how hardworking you may be, and I think you're a very hardworking judge, I think that you will make every effort, but I think that it is impossible for when we get up and make our motions for directed verdict that you can assess the now going into the 9th month of trial testimony. That's essentially basis number one.
Okay.
More importantly, I think that should you erroneously deny our motions for directed verdict, that you then would be in a position to sit on our motions for new trial. And that's the so-called 13th juror. We have put that in our response, and it is without question. We have our courts, the federal courts, all say that there is a distinction between whether there is sufficient evidence to go forward, which is the standard on a motion for directed verdict, and a 13th juror motion for new trial. You can find, you know, I denied your motion for directed verdict, but you know what? I just don't think that this was either a fair trial or a trial in which, based upon what I have seen, what I observed, that should stand, and I'm going to grant it. I mean, it's
What up, FFS? I see you. I'm still creeping through the chat. I ain't got there yet, but I see you, family. I ain't gonna leave you out. What up, fam?
entirely in your discretion. And that discretion is unreviewable, really, by the appellate courts. And they have all said, as we said and quoted in Wilkerson, that the discretion, the trial court must consider some of the things that she cannot when assessing the.
Okay, wait, I get it. What up, for fuck's sake? I got you. I got you, for fuck's sake. Okay.
Legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of the witnesses, the weight of the evidence, meaning that the trial judge may grant a new trial on the general grounds, even when the evidence is legally sufficient to sustain a conviction. So I know that we're going to stand here and make a motion for directed verdict, that God forbid, if any of these defendants are convicted, we will come back to you and say, Judge, motion for new trial, sit as a 13th juror. Don't think you can possibly catch up to that extent. Nor do I think that, based upon the cumulative nature of Judge Glanville saying, I heard you when you want a severance. I'm denying it now, but it may come to the point later that I'm going to grant it. So 3 reasons that nobody else has argued to you, essentially, for a motion for mistrial or a severance as to Mr. Nichols. 1, the motion for directed verdict. 2, the 13th juror. 3, the continuing nature of the motions to sever in for a Rule 105 instruction, a limiting instruction which the court said, you know, I'm probably going to give that at the end of the trial, but I don't think it's necessary to give it now.
Game. What up, Loa?
So,
Okay,
all of those.
I understand. And I don't really need to hear from the state on this one. With regard to the directed verdict issue, the standard, as we all know, is essentially an any evidence standard. It is entirely possible that just on what gets presented going forward, I will be able to rule.
Shout out to For Fuck's Sake.
On the motion for directed verdict, assuming we get there. But if not, I can and will ask for specifics from the state as to what the facts are supporting each count of this indictment. And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial is a basis to grant a mistrial in this case. With regard to the 13th juror, I understand that's a different standard. There are times it's not routine.
The 13th juror, huh? Refers to a legal concept. I'm going to pause that a little bit. Actually, I'm going to play it and let y'all read it. Y'all can pause it.
But it happens.
Yeah.
Then a different judge from the trial judge considers the motion for new trial and considers the 13th juror issue. And the appellate courts have recognized that it is a somewhat less deferential standard when they're looking at it on review when it is a different judge than the trial judge. So, you know.
Yo, shout out to Chan. My black is golden. Appreciate you being here, family.
If and when we get there, I will consider whether anything ought to be granted as a 13th juror, if y'all ask me that. And if I deny it, then the appellate courts can consider it. But that is not anything unprecedented. It happens all the time that one judge does the entirety of a trial and then another judge considers the 13th juror issue. So that is also not a basis on which to grant a mistrial. And with regard to the severance issue and the cumulative nature of that, I'm going to rely on you to point out to me everything I would be taken into consideration if and when you make that motion again. With regard to a 105 limiting instruction, I am happy to consider anything that you all think might be appropriate to give right now. Okay, so I invite y'all to submit something. Okay.
This isn't my motion. It should be my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I raised them. I put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy because if he flees, the case goes on with its mid-trial and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally.
Shadiggy said, I'm on Cleveland Ave. Too many police. Texting a few. Dizam. What up? Be safe out there, Shadiggy.
That's not before me. Those are not the kind of changed circumstances that speak to the ILL factors, and so I'm not going to reconsider the bond.
Well, let me ask one more then. There is a judge who joined the prosecution team. He said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should come anew.
Well, that may or may not be a substantive error in these trial proceedings. I've got that under advisement right now, but that also would not be an ILA type change circumstance. So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Okay. Even though potentially it was not done by a fair tribunal.
All right. There is nothing, and I'll make a determination with regard to that substantively, but I will note that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding, while I think dicta, was that there was nothing improper. She said, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts and information when he denied the motion to recuse, and that was not what the rules require, and so recusal was necessary. But she even, I think, went on to say, but even with that, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me, and if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then.
Hold on, so you see what she's saying, right? Like maybe they will be recused. I mean, maybe the recusal is kind of prejudice, but it won't affect the bond. It ain't gonna change the bond circumstances, so it don't really mean nothing. So I'm not gonna reconsider it.
That might be a changed circumstance, but right now we don't have that.
And I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing, not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, the same judge hiding Brady evidence. So I'd like you to consider that.
All right, thank you. I understand. It's not an appropriate consideration, but I understand what you mean.
Another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of Georgia?
Matthews, that is not an appropriate consideration for bond.
I would ask
Period.
you, understood, Your Honor. I'm asking the court to look.
She said, I don't care how much it cost them. That do not matter about no reconsideration.
Look at the resources that are required to have Mr. Huey here.
Boop. Shout out to Cat Not Williams. I know I'm kind of late on that boop, but what up, family? Shout out to Cat. Appreciate you being here, family. If you can, Steph JK, if you're here, please drop Cat Not Williams link in the chat. Appreciate you, family. If you don't mind.
Every day. That's all I'm asking the court to look at.
Consideration for bond. All right.
So essentially, Your Honor, I'm asking the court to look at the change in circumstances that I have cited in my bond motion. I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court. And the change in circumstances that I am alleging were done by the recused court.
All right.
Based on judgment calls. So, Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He'd be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law, and also, I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Schardt versus the state, 298 Georgia 438 of 2016 case.
What was that site? Is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Schardt court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial,
Okay.
so forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor,
Okay.
which we are alleging is a change in circumstances, a change brought about by the court and not by Mr. Huey. And we believe that that month and a half delay where he's had to sit in the jail.
Destined to be you. What up? I see you, family. Appreciate you joining.
We're asking the court to not only be a court of law, but to be a court of equity, which this court is. And we believe that equity and fairness dictate that a reasonable bond be set in this case. Otherwise, any other change in circumstances that are not brought about by Mr. Huey has to suffer the consequence. And that's what he's doing. He's suffering the consequence, Your Honor.
Okay.
Respectfully.
Thank you.
Thank you, Judge.
All right, so that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased.
No, it does not. No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
So that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased, was not that the ex parte itself was improper. It was that Judge Glanville engaged in an exposition on the facts in making his rulings on the motions to recuse. I understand the argument that the court who undertook the original bond consideration, in the defense's view, has become biased, but that in the same
Everybody know he biased. It's all over TV.
way that I said to Mr. Steele with regard to Mr. Williams, if I substantively end up determining that, then it may be appropriate at that time to take up bond again. Right now, it is not. And it is unfortunate that this case has lasted as long as it has. It is unfortunate that there have been delays in the case, but those do not, in this court's mind, amount to the kind of changed circumstances that make it appropriate to reconsider bonds. I am not going to reconsider or grant bond in Mr. Huey's case either. Mr. Kendrick also has a motion to reconsider bond. He asserts changed circumstances that essentially this case has taken way too long, which I don't necessarily disagree with, but.
I would ask you for Mr. Kendrick's bond motion, if you could defer ruling on that until after you rule on the mistrial.
All right, I will do that.
Thank you.
That would be more appropriate. Thank you. Okay. So the next thing I think that it would be appropriate for us to begin to undertake is some of the specific evidentiary motions. Mr. Stillwell has a motion for, it's entitled for reconsideration regarding certain hearsay statements, but given that we all acknowledge we're redoing Mr. Copeland's testimony, it's not even really reconsideration, it's consider it anew as we go forward. So I'll hear you on that.
Thank you, Your Honor. Before I get started, could I hand over a case? It's actually the Scudder case that Mr. Maxx referred to. And the reason I'm giving you this case, when you consider some of the issues that you said you're going to consider tonight, I never really, and I understand, I'm not complaining, but I never addressed my other motion, which may, in fact, not be a motion. But
for a fair trial?
Yes.
Okay.
But in the state's argument against Mr. Kendrick's motion, they're relying on King.
Right.
I would invite the court to look at the facts surrounding this ex parte meeting. It's clearly distinguishable in every way from King when you look at the facts. And I would just remind the court that King was involving a request, giving the court background facts to show that granting immunity to a witness was in the interest of the public.
Okay.
That had already been done in this case the Friday before. So it's completely different when they had the ex parte meeting on Monday, and I believe Scudder is.
Thank you.
What up, Tall Glass? I see you, family.
To consider, and it's much more analogies and on point to what happened in this case, and of course, Scudder.
Appreciate you being here.
Points out the problems with such a meeting and held that it was improper. Regarding this issue of Mr. Copeland, I appreciate the court correcting my label of what this really is. I agree that it's a consideration anew, and we had prior discussions about it. There was not a written order to this point.
And do you want me to take a look at the original consideration? If so, you'll need to point me to where I would find it.
I don't know where it is. And this is not,
start over.
I don't mean to sound like I'm being smart out here. It was discussed. Some of my motions were rushed over so quickly. I think I assumed that I had lost that motion in front of the prior trial judge. And I'm not sure if it was actually a ruling or not. I'm trying to, if I could go back to my seat for a second.
Sure.
Attorney Love, they are not only wrong, but I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Ms. Love intentionally, I assume, she has a memory of this because she was here. I hand her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court will look at United States versus Harry, which should be in your package, I may not have put this in perfect order because one of them were not stapled, but you should have United States. Okay, and Harry is H-A-R-Y, and it is 2014 U.S. District Lexus, which is L-E-X-I-S, 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy of the honorable court and the parties. And if you can turn to that page, if you don't mind.
I'm there.
On the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the Fourth Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the Fourth Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, H-S-I-A, the Fourth Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the Fourth Circuit held, encompass both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The Fourth Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there has been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, G-R-E-E-N. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be G-R-E-E-N, and it's 368 Georgia Appeal 74. 889 Southeast 2D 190, 2023. And what the Honorable Judge Pipkin, which is P-I-P-K-I-N, states, and Your Honor, you could look at, if you don't mind, at this case on page 3 of 5 of the copy I've given the parties. And this Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. And the footnote they wrote, and I'm quoting, we also agree with appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tally them, but TALON note was in fact a discovery violation, given that talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and that gives the 2 code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this Honorable Court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this Honorable Court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3, and that's where the 1 is in 17-16-4 in the copy I've given. And it says that the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney, at a time agreed to by the parties, or as ordered by the court, to inspect and copy books, books, papers, documents, photographs, tangible objects, audio and video tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to Honorable Court and the parties, and that has, if you give me 1 second, that has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel that relates to the...
Yo, shout out to Snapper Slapper. Yo, there is a way I can set up to where you could gamble points. I don't have it set up right now, but I can arrange that to where y'all can gamble points. So we can talk about that. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend.
Subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with who's case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other grain. So it is GREEN versus state, but it's 307 Georgia 171, 835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 5 of 7, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence in defense, I apologize, in the defense case in chief or rebuttal the results of the scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor, which is CARMICHAEL versus state. 353 Georgia Appeal 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of the Honorable Court and the parties, page 7 of 8. And Your Honor, this is on the left-hand side. The first full paragraph, accounting from the bottom. 9 lines up on the right. I'm quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts of other parties, you can accept those facts as being true without further proof. My point is, case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases. It's on page 8 of 17 of United States versus Harry, Your Honor. It's well written. It's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico,
what up, Daniel Berry?
wrote,
I see you, family.
courts have repeatedly used.
What up, Daniel Berry? I see you. Appreciate you being here, family.
The term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the 4th time in doing this, The state then has, or the court said that wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not,
I do.
So, in United States versus Waddle, which is Waddell, and it is 2016 U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the District Court in Southern District of Georgia in the Savannah Division. Your Honor, if you go, and I'm not saying we have the same copy, so this is on...
Don't worry, we got some Woody coming up. You miss Woody? We got some Woody coming up. Shout out to Snapper Slapper. And stay tuned. You'll learn how to use the points. They scrolling at the bottom, so that kind of explain it. But you just hit exclamation point, and then whatever the chat prompt is, you get points by staying active in the chat. Appreciate y'all being here. Let's go, family.
I have page...
Maybe what page of the slip opinion?
I'm trying. I think it's page 11 is what I'm looking at. It starts out with one final point. Mm-hmm. Okay. So the Waddell case, the judge said, no, you don't have to give it over. But if you're lying, I'm not saying that's
right. No, I read it. Yep. Mm-hmm.
Then you're going to be in a lot of trouble or something to that effect. But what happened, the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
that's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigator, she called me, give me any recordings that you have of Mr. Bean. Now the investigator's skilled. So he must have said I wasn't on the phone.
Shout out to nobody. Welcome to the fam. Appreciate you being here. Let's go.
But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't give me anything. Said Mr. Steele's investigators obstructing us. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting? I am never taking Ms. Love's proffer. Okay, so she says that I said, I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I said...
Is there somebody on the state's case that you are able to talk to?
Yeah, Ms. Willis.
All right. Well, okay.
On the second page, and I'm just looking at the amendment to supplement, on page 2, in the center of the page.
Right.
And I should start above, but I'll get to that if you don't mind. For another example, Defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a...
Yo, shout out to Kristen Vasquez. I got that message. You said that earlier, and I included her tonight. I got some Judge Hatchet coming up, so appreciate the shout out. We got her coming up tonight.
Social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you're going to have to, I don't have to give it to you. I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything.
Shout out to Texas T. What up, fam? I see you.
But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness.
YP Com Chick, what up though?
They want me to tell them which jail calls am I going to use to impeach the man. I said I'm not going to do it. Judge Glanville said you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. And then to stand here and say I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me if he was there for 3 or 4 days. All he said was, I don't recall. That's what he said. I don't recall. Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr.
Facts that time. I see you, family. That's a fact right there. They always communicating together.
Being in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt, out, no evidence. And then in the middle of that document says that Brian Steele and his investigator, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Miss Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected, outrageous. Outrageous. That just flows right through. The same way Miss Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis
What up,
is
Pink
wrong.
Slime? I see you.
There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without being tempered.
All right.
That's 4 times.
Thank you, Judge. Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and to the extent that it wasn't.
A copy of.
Yes.
Okay.
And also, I just want to say that
no Georgia law.
Right. Georgia law does not define. It does not.
It does not define. Hey, what up, Brandy P? I see you, family. We just getting into it. We got a good one coming tonight. Appreciate y'all being here. Make sure y'all hit the like, hit the subscribe, tap in, share with a friend. We got some good stuff coming up tonight. Appreciate all y'all being here, fam.
Define case in chief. It does not break it down.
We all know what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Yeah. Your Honor, what I have said and what I maintain is
Pregnancy does not just happen. I mean, you don't just wake up one morning and you're pregnant. Why aren't you taking some precautions if you don't want to be pregnant? Which means that the same way that you get pregnant, you can also be exposed to all kinds of diseases. That there are things out here now that penicillin will no longer cure.
There are, and I don't know if this falls under the discovery that we were going to talk about tomorrow, we are missing the reports of many experts that the state plans to call, is my understanding. Also, Your Honor, there are, in this case, the state, I believe, has announced that they plan to call 5 different gang experts.
And they've called 3 at this point, is that right?
I believe that is correct. I believe it's 3.
So maybe explore what, if anything, the other 2 are going to add.
And not only that, but the state has announced the intention to call a few of them multiple times.
Okay.
So that is another issue that's continuously come up in this case. Am I missing anything from our list? That was it? Okay.
Okay.
So those are the issues that we came up with.
Thank you. All right. And if the state needs the evening to,
sort out everything and make sure that you're.
Yo, YP, I think it's just I love Bobble, no head.
Being inclusive and answering to the extent you know, that's fine. But if you know now, that's also fine. Do they have notice of all the different co-conspirator statements that the state intends to use and the extrinsic acts the state intends to use? Y'all can answer now, or y'all can say.
I'm sorry, I don't recall.
All right. And you didn't kill him, correct?
How many times you gonna ask me that? I'm saying what y'all want to pick and choose with. Okay, I don't recall.
Pull up screaming, break, break. Pull up screaming, break.
Young, you said nothing I say can be used against me?
That's right.
Me and Threat shot up Rich Homie Coin Daddy Barbershop on Bankhead. I don't know what happened with Threat and Rich Homie Coin, but I'm a ride with my brother. And they was beefing. And yeah, we pulled up and did that.
Ooh, fuck nigga try me, I swear I got Lil Woody, pull up and pop at it nagging. Half time, half a perky, half a zany nigga, half time, half a paper, take my nigga, half time.
And is that why you're changing your testimony here today? Because
I'm not changing my. I'm sorry. Go ahead.
Because you're concerned about being labeled a snitch.
I'm Judge Whitaker. I think you've been before me before in unrelated matters. I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I never wanted to be testified.
Okay. The first, well, right, want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no then if you don't know whether.
I was talking to Melanie, but.
Melanie?
What up, Daniel Hauser? I see you, fam. Appreciate you joining.
Yes.
Okay. Didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred. I believe that Ms. Bumpus,
I know she was stand-in.
She was stand-in, and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
yeah, I know she was.
There was nothing about Mr. Melnick, to my knowledge.
Okay, maybe we.
There was. Miss Bumpus actually said.
Shut the fuck up! Got him! Got him! Oh! Whoa! Whoa!
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case.
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So if I don't testify, So if I don't testify, how long will hold me in jail?
So, Ian, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial?
Yes.
Not the other people.
Not as far as I believe, but the state. What did you want to do some further research on that?
Yes, just to advise the court of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here, like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead. Okay.
All right.
All right. Thank you.
So guys, I just want to say that even though Woody fired me, as you all know, I still have to protect his interests. And I want to say we will not be talking about the case. He cannot answer anything. Woody, is the transcript complete? You say no?
You know that.
Well, I guess the only thing that I should have said that I didn't say is that Simone said that she would not prosecute or move forward with any type of perjury if he said anything except for the unaliving of Donovan Thomas.
Okay. All right. All right. So when is it that you actually reviewed and read this transcript?
I really don't know. I think maybe around the time that I had to retain counsel, I think we reviewed it together, which I cannot tell you the exact date. But
sometime in late June?
Yeah, somewhere after 6/12.
Okay. And we all in this room know this to be the case, but you're an attorney licensed and barred to practice in Georgia, right?
Yes.
Okay. And as such, you have a duty of candor to the court?
Yes, Judge.
Okay. Is there any point in time after you read this transcript and thought to yourself, wow, that really doesn't include everything, that you brought it to this court's attention that the transcript was incomplete?
This court, well, there really was no court's attention to bring it to, because after all that happened, it's been on recess for so long.
So you've been in court when we've been in session for the last week or two, right?
Yes.
Okay. So I was presiding at that point in time, right?
Yes.
Did you at any point bring to my attention that you believed as an officer of the court and a participant in this ex parte meeting that the transcript did not accurately reflect what occurred in that meeting?
Well, Your Honor, I did not bring it to your attention, and I honestly still would not, as an attorney, if I can answer this as an attorney.
I still wouldn't tell
I
your
believe
ass.
that there is some value in off-the-record conversations for specific things, and it has always been my position, even in speaking with members of the defense, that as far as anything minus the off-the-record conversation, that the transcript is complete.
Okay. All right. So what is your answer then to my question?
Can you ask me again? I'm sorry.
Did you ever at any point in time bring to my attention your belief that this ex parte transcript was inaccurate because it was incomplete?
No.
Okay. Why is that?
Well, because of what I kind of just said, I don't believe that it was incomplete per se, minus the off-the-record conversation, but there are a lot of off-the-record conversations that are had that are not included.
You see how the judge set her up and did her? She shut her down real quick. She wasn't prepared for that one.
Transcripts, and that's not unusual to me.
All right. So you don't actually believe it's inaccurate then?
No, I just think it's missing the off-the-record conversation. I'm not missing. I just think that the defense did not have knowledge of the off-the-record conversation. Not that it's missing from the transcript per se.
Okay. Because it was officially off the record. Is that what you mean?
Yes, Judge.
Okay. And did you ever, if it in fact occurred, did you ever object to it being off the record?
No, I didn't.
Okay. So at some point you brought...
Yo, Steph JK, is that true? True? How y'all say true? Do. Do what it do? What you about to do? You ready for Philly? Shout out to Philly. Much love, fam. Shout out to Steph JK.
It to the defense attorney's attention? Is that how you decided to deal with it?
I had a conversation with the defense attorney. I don't want to say I brought it to them, but we just had a conversation about what happened.
All right, Ms. Love, do you have any questions for Ms. Bumpus?
Ms. Bumpus, did you tell any member of the defense about the details of the content of the off-the-record conversation that you had with Ms. Hilton on June 10th?
That I had with Miss Hilton and Mr. Copeland? Yes.
When did you tell them?
The same day.
Did you tell them everything you remember about it?
I told them everything I remembered.
Do you remember how long after the conversation took place it was that you told them?
I don't know, maybe like an hour?
The gatekeeper. Was court in recess or was court in session when you told them?
Court was in recess.
Between the time that the conversation between you, Ms. Hilton, and Mr. Copeland ended, and the time that you told defense attorneys all of the details you could remember about the off-the-record conversation, was court in session at any point?
I'm sorry, can you repeat that?
Was court ever in session between the time that you finished your conversation with Ms. Hilton and Mr. Copeland and the time you told defense? What happened in the meeting?
Yes.
Court was in session during that hour?
Had court resumed?
Correct. Did court at any time resume from the time that you left the meeting in chambers to the time that you had the conversation with defense? Just in that moment, from chambers to conversation with defense?
Oh, no.
Court had not resumed?
No.
And when you said earlier,
I mean, because remember, we came straight down here and sat down and immediately started, so I didn't speak to anyone.
and when you were speaking earlier about after Mr. Copeland came in, you said you weren't sure whether I was in the room.
Mm-hmm.
Did the portion about Judge Close Your Ears occur before or after Mr. Copeland came into the room?
For sure before.
Okay. And at that point, was the court reporter taking down anything?
No.
And at that point, did the court give any indication, did the judge give any indication that he was paying attention to whatever the word was?
I can't answer that.
Did he give any indication? Did you see any indication that he was paying attention?
I can't answer that. Yeah, you can. I don't know. I wasn't paying attention to him. So no, as far as you know, he gave no indication. She's asking from your personal observation. Answer it as to that. That's what she's asking you. I would have to say no, but I would also say I wasn't looking at him at all.
Do you remember Miss Hilton at some point talking about the judge closing his ears at any time?
I don't remember.
And with looking at the transcript, I'll refresh your memory.
I'm sure.
Okay. Would you take a look on page 26, line 5 of the transcript? And since it's a part of the record, read from line 2 to the end of line. Let me just ask you this. Do you see where Ms. Hilton says, Judge, you might want to close your ears?
Yes.
Did you hear that phrase or something like that said more than once in that meeting?
Yeah, before Simone got there, I know exactly what I'm talking about. So are you in here at this point?
So my only question is, did you hear that phrase more than once in the meeting?
I can't remember if it's that exact phrase, but I heard you say something to that extent, and I heard her say that.
Okay. Were you the first person, to your knowledge?
Shut the fuck up! Excuse me, objection, Your Honor. We're still far afield again of the limited subject matter that you asked me to stick to.
Your Honor, as it pertains to Brady or whatever information, I think it's quite relevant. Who knew what and when, as it relates to what was said during the meeting?
Okay, well, I don't know if it's relevant who revealed it. Who revealed that a meeting occurred? Ms. Bumpus has said that, essentially, if I understand you correctly, that at some point during the day immediately following the meeting, the day of the meeting, you had a conversation with some defense attorney or defense attorneys, and we can sort out who, where you relayed to them everything you knew and everything you recalled about what went on in the meeting, including the off-the-record conversations, right?
Yes.
Okay. You can figure out who that is now.
Which attorneys, by name, first came up to you and asked you about the meeting?
See, Judge, that's two different questions. Then answer the question Ms. Love asked you.
I don't recall, but I think Judge Glanville did judicial notice of me on camera. I don't recall.
No, my only question to you is who first came up to you and asked you about the meeting?
I don't recall everybody who was there.
Who do you recall?
I recall Attorney Steele and Attorney Adams. I can't remember who was the other person.
When you agreed to represent Mr. Copeland, did you, during the course of the meeting that you had in chambers, did you ask questions of the prosecutors or the judge about what the immunity statute meant or anything like that?
Yes, I asked a lot of questions because I didn't realize until the end of the meeting what was actually going on. That information wasn't given to me.
That's all.
All right. So, Ms. Bumpus, you knew to show up for court that Monday because Mr. Melnick had asked you to be stand-in counsel for Mr. Copeland, right?
Yes, Judge.
Okay. Are you representing that Mr. Melnick simply said that and nothing else? He didn't give you any background about what you were walking into?
Well, what I'm representing is I was given specific instructions. And those instructions were, I'm standing in for him. If Mr. Copeland chooses to plead the fifth, which I anticipate he will do, then you won't have to do anything else. If he chooses to testify, we have agreed that he's discharging me.
Okay.
And I made that very clear to everybody multiple times that morning that that's what I was here to do.
Okay. But you had no idea that there was an immunity order in place?
No.
Okay. All right. Does anybody from the defense side have follow-up questions for Ms. Bumpus?
I have just a few, Your Honor.
Okay.
In your cross-examination, you said, quote, she says she is not going to prosecute him for anything other than that one thing, unquote. What is that one thing?
I can't answer that. I can only assume it would be the unaliving of Donovan Thomas, but those are the words that she chose to use.
When you say unaliving of Donovan Thomas, what are you referring to?
I get him being killed.
During cross-examination, Ms. Love asked you about some alleged retaliatory acts. Were those being discussed when Mr. Copeland repeatedly said, I can claim all of this, I can take all of this?
Nothing was being discussed.
What do you mean nothing was being discussed when Mr. Copeland said, I can claim all of this, I can take all of this?
He said that on his own, and that's kind of how the conversation started.
What was the subject matter being referred to when you said, I can claim all of this, I can take all of this?
Donovan Thomas's murder.
Okay. I have no further questions.
Anybody else? While Mr. Steele's making his way up, just so I am clear on this, you're saying that are you saying that in the off-the-record conversation that you, Mr. Copeland, and Ms. Hilton had, that Ms. Hilton told Mr. Copeland that the one thing she would prosecute him for perjury for was if he got on the stand and said that he, Mr. Copeland, was the one who killed Mr. Donovan Thomas?
Yes, Judge.
Okay, and that she would prosecute him for perjury if he said that.
I don't know if she exactly said would, but she was comparing it to things that she wouldn't.
Okay. All right.
So I guess more of a highly possible situation.
That would be the one thing that could get him in criminal perjury type trouble. Okay, thank you. Go ahead, Mr. Steele.
Thank you, Your Honor. I just wanted to do timing or sequencing you were asked about. When you left Judge Glanville's chambers, after not bathroom breaks, after Mr. Copeland was removed from the chambers, etc., where did you go, if you remember?
I came and sat right there in the courtroom.
At that point, had you spoken with anybody to alert anyone that there was an ex parte meeting?
No.
Where did next time you saw Mr. Copeland was when? When you left the ex parte meeting, came into the courtroom?
Up here. He was up here.
Testifying where you're sitting?
Yes.
Okay. And then did the jury come in?
Even them having to sit here and hold this meeting right here, this hearing right here, this should already be a cause for mistrial. Y'all sitting here talking about what the judge and the prosecutor did in the ex parte meeting that they wasn't even supposed to be in. What the hell? Let's go, family. Hit the like button, man. Let's get it up. Let's spread this info, family.
Yes.
And did Mr. Copeland testify before the jury?
Yes.
At any time during that moment when Mr. Copeland's testifying in front of the jury, did you tell anybody about this ex parte meeting that you attended?
No.
Or the contents?
No.
Okay. Do you remember there being a break at any point for lunch?
Yes.
Is that the first time you were approached?
Yes.
Ex parte meeting?
Yes.
True?
Yes.
Did anybody, and that's after you were under no restraint, you told the truth?
Yes.
And that was to myself and the other people you told?
Yes.
True?
Yes.
Thank you. Thank you, Your Honor.
All right. Mr. Schardt?
Can I ask one more question? Sure. After the lunch break, do you remember when I raised it before Judge Glanville?
Yes.
Did I do it right away after we spoke?
Yes.
First time the court reconvened?
Yes.
Thank you.
All right.
Ms. Bumpus, were you in the courtroom when Mr. Copeland was called to testify after the ex parte meeting? Were you present in the courtroom?
Yes.
Okay, did you hear Judge Glanville, did you hear him tell anyone from the defense that an ex parte meeting had occurred?
No.
Did you hear anyone from the state tell the defense on the record that an ex parte meeting had occurred?
No.
Was there any discussion about the substance of said meeting?
No.
Okay, thank you.
Anybody else?
I do think I think that it's not. I do think that I helped the defense because the only part that I was supposed to get out was, and at this point, it's about integrity. It's not about anything other than that. So you got to understand. Like I said, I was sitting in the courtroom. I had no idea that I was about to testify until I'm sitting in the courtroom. Nobody talked to me prior to Judge Whitaker.
How y'all think she did? Y'all think she did what she was supposed to do, or y'all think she had an opportunity to do more? Y'all let me know if she should have smashed that a little bit more, or should she have been safe and kept her career more safe like she did? Y'all let me know.
Saying the only person I'll take that from is Miss Bumpus. The only thing I was supposed to say was that there was an off-the-record conversation and that there was Brady information disclosed in that off-the-record conversation. That was my burden, and that's what I did. Nobody knows what it feels like to be in my position. At the end of the day, throughout this whole situation, why would I risk my career, my reputation? I've been saying from the beginning that I don't want to have beef.
Nutty fluffies. What up? Shout out. Appreciate the likes. She just said it. Why would she risk her career? And I can respect that. But I mean, I can respect that. So I just want to know what y'all think.
With nobody in the DA's office. So I want to let you guys know it took a lot for me to get up there and do that. There's no reason for me to lie. I told the truth. I was not nervous. The courtroom is like -0 degrees. So I was freezing. I was freezing cold. And all I did was got up there and I spoke the truth. And it's the same things. It's so confusing to me because it's the exact same things that I have been saying all my life. I was not the first one to tell about the meeting. I've said that over and over and over again. I was not the first person to tell about the meeting. I said that. I've said over and over again. The transcript is complete minus the off-the-record conversation. I said that. I said that I did have a conversation with members of the defense, and I told them everything that happened from the beginning to the end procedurally. I said that. No, wouldn't you have to disclose anything that's Brady off the record or not? That's the whole point. The point is that the prosecution did not disclose Brady information. That's the whole point of this motion. The whole point of calling me as a witness was to say that Ms. Hilton heard Mr. Copeland say he knew something about this infinity, that we have 5 witnesses. So we have 5 witnesses that testify about the infinity. Mr. Copeland is here saying he knows something about the infinity, and she did not turn that over to the state. Also, the main part of the Brady was that
she looked shook, though. I think she was scared, though. She still looks scared. You see the way she did that? She's still catching her breath. Shout out to Kayla, though. I ain't mad at her. She could have did more. I will say she could have did more. That was a chance to expose some Brady evidence. But then again, I respect her. I ain't mad at her. Shout out to Kayla. She did her thing.
He said that he was a liar and that he would confess to all of the crimes. All of the crimes. And some of the parts, somebody said I look confused.
Like that part right there. Hold on. You heard her just say he confessed to all of the crimes. She didn't say that when she was on the stand. He said all of the crimes. That would have made a big difference.
Because at a certain point I was confused. All of the crimes. So the main part of the Brady was that he said that he was a liar and that he would confess to all of the crimes. All of the crimes. And some of the parts, somebody said I look confused because at a certain point I was confused. I was confused as to what we were talking about because Adrian was able to talk about things that had nothing to do with the subject matter of was there an off-the-record meeting. And that's fine. I don't have a problem with it, but it was confusing. Her questions were confusing. There were multiple times where even the judge said, at one point, I'm just as confused as you about a question someone asked me.
Can I tell you what I do remember?
Is that about the shooting on the highway?
No.
Then no, not right now.
Okay.
Or let me ask you this: do you remember what you told Detective Gaither in January of 2015?
No, I was gonna tell you what I remember from when Nut was killed.
Okay. Tell me what you remember the night that Nut was killed.
I remember everybody said I killed him. That's all I remember.
Then that's the only thing you remember.
That's all I remember. I don't remember nothing that night. I don't remember where I was. I don't remember what I told the investigator. I thought that when they called me down there, I thought I walked in and he let me walk right back out. I don't remember sitting down talking to him. I don't remember him doing no ballistic. I don't remember him. I remember he said one thing and he left. He said, the man sitting on the street and everybody saying you did it. He like, man, I still got a bite on the street. That's all I remember. I thought I walked in and walked back out. I don't remember nothing. Like,
And that was the first time when he went to go speak with Thorpe.
I don't even know if it was. I know.
Yeah, I think something happened with the mic. All of us.
Facts, that Loa. You here talking about candor to the court? What about love? No love. Loveless. Lawless love. She definitely ain't got no candor. You should be saying that to her every day.
Of course. I don't have a way to say it.
Gatekeeper.
Just correct me. I'm trying to understand myself, okay? All right. First of all, the off-the-record portion of this ex parte meeting, you said that Ms. Weaver, the court reporter, did come in to the judge's chambers, the judge's back room and chambers during that discussion, correct?
Everybody was coming in initially.
Okay. And that was before what we're deeming the off-the-record conversation, correct? And Ms. Hilton specifically requested Ms. Weaver not to take those communications down, correct?
I wouldn't say she directed Ms. Weaver, but she did say she wanted to talk to Ms. Bumpus before we went back on the record.
She made the request, Ms. Hilton. Okay, and that was, to remain off the record was requested by Ms. Hilton and Ms. Hilton alone.
Yes.
Can I get a little clarification there? So this is after the restroom break, right? Or whatever kind of break it was?
Yes, Judge.
Okay, and when Ms. Hilton said, I want to speak off the record to Ms. Bumpus for a minute, was Judge Glanville already in that room by then or not?
He had stepped in and ended up stepping back out.
Okay, and so, all right.
Yeah.
But y'all know she was telling the truth because it was proved by this guy right here, Miss Deputy Long or whatever his name is, ADA Long, that she was telling the truth. So they couldn't do nothing to her, so she did tell the truth. But it sounded a little different on her own lines. But she did her thing though.
Thank you.
And you indicated that during this off-the-record portion, Ms. Hilton stated to Mr. Copeland that she would not pursue perjury charges unless it was a blatant lie. That was said during the off-the-record portion, correct?
No, that's not what I testified to.
Okay, when was that statement?
I don't ever recall her saying that she wouldn't seek charges unless it was a blatant lie.
Okay.
I think she was trying to explain the difference between the inconsistent statement and then a outright lie, if I can use that terminology.
Well, what did she say?
What do you mean what she said?
Well, you said that when I said she would not pursue perjury unless it was a blatant lie, you said that was not what she said. So what did she say regarding that?
And off the record?
Yes.
Her statement or comment to Mr. Copeland was that if you did get on the stand and you took claim or took credit, this is me paraphrasing, for something that you did, then knowing that you didn't, knowing we know you didn't do it, then she would see.
Shout out to Time. Say I believe she would have did better if she could have took notes. Yeah, I believe that too. And also she said, according to her, she didn't know she was gonna go up there. So to be unprepared, that's another thing too. It's like just on the spot, you didn't have no time to prepare for it. That's different. If you had a couple days in advance, you could have studied the transcript and whatnot, but who knows? Fulton County still grimy.
Perjury charges for that.
Okay. And you indicated, my understanding of your testimony is you indicated that at some point, Ms. Hilton specifically referred to getting on the stand and claiming responsibility for the Donovan Thomas situation. Is that correct?
Yeah, if he took credit for something he didn't do, yes.
But specifically, it was stated the Donovan Thomas situation, correct?
Yes.
Okay, and that was out of Ms. Hilton's mouth?
Yes.
Okay, so Ms. Hilton specifically, during the off-the-record portion, referenced Mr. Copeland taking credit or taking responsibility for the killing of Donovan Thomas.
Yeah, it didn't come exactly like that, but yes, it just yes.
And Ms. Hilton specifically said that if Mr. Copeland did that, she would seek perjury charges against Mr.
Bees on Mars, what up, family? I see you. Appreciate you joining.
Copeland, correct?
If he got up and he took credit for something he knew and he didn't do, yes.
Well, you keep going back to you didn't do, but in the fact is, in that off-the-record portion of the conversation, it wasn't just generally something we know you didn't do. She specifically said
it was both.
Killing. Okay, so it was specifically something we know you didn't do, and then she also said specifically for claim responsibility killing of Donovan Thomas. Okay, so to your recollection, if you recall, prior to Ms. Hilton, did Ms. Hilton just bring Donovan Thomas, that case, into the discussion, or did Mr. Copeland say something that Ms. Hilton was responding to when she warned him not to take credit for the Donovan Thomas killing?
Ask the question one more time.
What did Mr. Copeland say before then that prompted Ms. Hilton to start talking about Donovan Thomas's murder?
Mr. Copeland didn't say anything. I can only, I believe Ms. Hilton was attempting to just explain, because he had received use immunity, not to go in and try to claim something that he did do because he received use immunity.
So your testimony is Mr. Copeland didn't bring up Donovan Thomas, but Ms. Hilton brought up the Donovan Thomas murder.
Right.
Did Ms. Bumpus bring up the Donovan Thomas murder prior to that?
Not that I recall, no.
And how was it determined when Ms. Weaver was going to start making a record of this meeting again?
I don't know how it was determined.
Did someone call her in? Did someone ask her to start recording now or taking minutes now?
Yeah, I believe if you're asking what made her prompted to, yeah,
Yes.
yeah, we said, I don't recall if it was Ms. Hilton, but Ms. Hilton may have said we're finished talking, and we called everybody back in.
And instructed the meeting to go back on the record? Instructed that the meeting should go
I
back on
don't
the
know if we
record?
instructed, but we were clear to go back on the record.
I have no further questions. Thank you.
Thank you.
Anybody else?
How you doing, Mr. Steele?
I'm okay. How you doing?
I'm doing fine. Blessed and out of favor.
Can I
Shout out to Martina. I respect that. I feel that.
ask you a couple of questions?
Yes.
What was your understanding, if you had one, of why you were having this ex parte meeting?
Objection, Roberts.
Sustained.
At what point were you initially told that you're going to this ex parte meeting?
Objection, Roberts.
I want to know which part he was there for. The beginning part, he said he came with Miss Hilton. I want to clarify.
Ask your question again.
At what point did you become aware that you're going to this ex parte meeting?
I'll allow that.
I believe that morning.
And when you say that morning, was it before the meeting began? Did you know when the meeting began?
It was before.
Okay.
It was before the meeting.
And who alerted you that?
Miss Hilton, I believe. Yeah. 'Cause of course we had to escort him over to the judge chambers.
And did you escort, when you say them, who did you escort to this? Say one more time.
Miss Hilton.
And was Adrian Love already there in the meeting, or did she come with you or go after you?
She was already there.
All right. Now, how often, besides this day, have you had these type of meetings with Judge Glanville?
With me, just this one.
How about with other people that you know about?
With Judge Glanville, no. Never happened with Judge Glanville.
Well, in this case.
Just this one.
Okay. All right. Thank you. Thank you.
You're welcome. Anybody else from the defense?
Shout out to Cat Knight Williams again one more time. I just dropped her link in the chat. Y'all know she got great content, great love. Most of y'all is part of the family over there, and I appreciate y'all for being here as well. Just wanted to send her a shout out. I just dropped her link in the chat for those who don't know. Go check it out. Appreciate it. Let's go.
Go ahead.
Did anybody tell you that that was not to be told to other people who are not invited to that meeting?
What's the relevance of that?
The state of Georgia, I objected to it, made a statement that I somehow knew about this beforehand, which is not true. So I want to ask if anybody directed anybody to tell somebody from the defense, not tell anybody from the defense.
Hold on, I would. Your Honor, I never.
Melissa, what up, family?
I did not represent to the court. That's fine. It's all right. I'm going to allow the question.
No. If I'm saying it correctly, did anyone tell me not to say anything?
One more time, you spoke very
Y'all
fast.
just
I'm
shut
sorry.
down.
What was your question? Did anyone
Hold on, my bad. I was shouting out Melissa, but let me play that one more time. You see how she shut her down?
tell me not to say anything?
Hold on, I would. Your Honor, I never. I did not represent to the court. That's fine. It's all right. I'm going to allow the question.
No. If I'm saying it correctly, did anyone tell me not to say anything?
One more time, you spoke very fast.
I'm sorry. What was your question? Did anyone tell me not to say anything about this meeting?
Yeah.
No.
Did you tell anybody about the meeting? Did you personally tell anybody, me, any of the other defense lawyers, any of the people accused of this meeting?
No.
Thank you. No.
Mr. Matthews. While Mr. Matthews is making his way over.
Yes, Your Honor.
Okay. Can you flip to page 41 and take a look at, well, the end of 40, starting at line 20, and then review that through the rest of the rest of page 41?
I'm done, Your Honor.
All right. Is it a fair characterization that during that portion of the meeting, Ms. Hilton, Ms. Bumpus, and Mr. Copeland are talking about what might or might not get him charged with perjury or false statements?
Yes.
And does Mr. Copeland raise the issue of murder and whether it has a statute of limitations?
Yes.
Okay. And does Ms. Hilton at some point after that talk about if she knows that he's lying about something and there's no other evidence, what that might or might not result in?
Yes.
All right. Do you recall whether the off-the-record post-bathroom break conversation occurred before or after this on-the-record conversation?
Give me just a second, a little pass, just to make sure.
Sure.
Shout out to Che Love Sick. Thank you for this love. Still had tiny balls here. She lost them very quickly after the first couple of days with Whitaker. That's a fact. Appreciate y'all being here, family. Hit the like, hit the subscribe, tap in, share with a friend. Remember when he was looking through the paper?
It happened after.
Okay. If you take a look at the entire rest of the transcript, do you think you might be able to figure out about when that break and off-the-record conversation happened?
I will take a look.
And I mean, you may or may not be able to, but if you can, let me know. If you can't, let me know that as well.
Oh, my bad, I was on mute. Look at them filtering through the paper though. Like, why don't the ones when Love got them on the stand? They don't get to do all that. I believe. But whenever
page 52.
Just like everybody been saying about Sprinkle looking all at his laptop, like why y'all get to read directly from the paper? We played a lot of those videos too. The cops just reading, like old girl that said the white shirts. Remember, she was reading straight from the paper. She couldn't even say none of her own thoughts. That shit was straight from the paper. That's what the papers say.
Can you find out whether that's somebody who has a Rule 22? And if it is not, they cannot come back in with that phone. Thank you. Go ahead, I'm sorry.
No problem. Your Honor, I believe 52, around 13, 14.
Okay.
When we come back in, let's see. Yeah, I think somewhere around in there.
Okay. And a break is actually indicated at lines 9 through 13 or so. Is that right? Okay. Right. And then at line 14, the court remarks, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions?
Yeah,
so it's right before that the off-the-record conversation occurred? Okay, thank you. All right. Any other questions by any counsel? Defense counsel? All right. Anybody else? Silence equals none. Okay. And Mr. Copeland were all in chambers, but before the judge was back in chambers? Or just tell me, maybe I'm yes, no?
Yes, we broke for someone to use the restroom.
Okay.
And before we went back on the record, that's when Ms. Hilton and Kayla had the conversation before Ms. Weaver began to record everything.
So Ms. Weaver was sitting in there?
She was not in there at the time. They were off the record.
Okay, well, I mean, you can be off the record and still have the court reporter sitting in there, so I'm just trying to get clarification. So this was after a bathroom break.
Right.
Ms. Hilton and Ms. Bumpus head back into chambers before the court reporter and the judge are back. Is that right?
Well, I want to say Ms. Weaver did come in.
Okay.
And then Ms. Hilton did ask, she needed to say something with Kayla.
Hold on, time. That's another fact. And Ms. Hilton was on vacation. She was like, I'm not going to be there for this shit. I am not showing up for that one.
And Mr. Copeland before the judge came back on the record.
And Mr. Copeland's in there at that point in time?
Mr. Copeland's in there.
All right, and so what is the substance of that very brief 2-minute or whatever conversation?
It was Ms. Hilton explaining to Mr. Copeland that if he did get on the stand and take credit or try to take credit for something he didn't do, she would then seek prosecution for perjury.
She would
seek prosecution for perjury.
And did she talk with any specificity about what crime or crimes that would include?
She did mention the Donovan Thomas case, and that if you got and claim something that he knows he didn't do, and we have proof that he didn't do, then she would prosecute for perjury.
All right, and so your recollection is that that conversation occurred off the record before the judge was in there?
Yes.
Okay. Do you have a recollection of a very similar conversation also occurring on the record?
No.
So if it's reflected on the record that that's the conversation that occurred?
Say that one more time, Judge.
Were there two very similar conversations about that where Ms. Hilton is saying, if you get up and say something that we know you didn't do, we're going to prosecute you for, or we or I'm going to prosecute you for perjury?
During the course of the conversation, Mr. Copeland's concern appeared to be his statements, or inconsistent statements.
I'm talking about just the off the record now.
Just off the record was just in reference to him taking responsibility for something that he didn't do.
Okay. I have no idea why that phone is ringing or how to turn it off. This is not my courtroom, so we're just going to ignore it. That phone being the desk phone on the bench for some reason. I don't know why. Okay, sorry about that interruption. All right, and you only recall one conversation about that, whether it occurred on or off the record?
I only recall one conversation specifically in reference to Ms. Hilton saying that she would seek perjury unless it was some blatant lie.
She would or she would not?
She would not, unless it was a blatant lie. If she wasn't concerned about inconsistencies that she would impeach, she would just impeach him for inconsistencies.
Okay. So do you recall any conversation where Ms. Hilton says, and this is on or off the record, Ms. Hilton essentially says, look, if you get up there and you claim something, that you're the one that did something, and I flat out know you didn't do it, I'm not going to prosecute you for perjury for that because I don't know what your reasons might be.
I don't recall a conversation to that. I do know that she used an example that she would have to corroborate something before she prosecute.
Okay. All right. So the extent of the off the record before the court got back in their conversation was her essentially just saying what?
Her conversation was in reference to him getting on the stand and taking responsibility for something that he know that he didn't do, or falsely admitting to something that he did after receiving use immunity.
All right. Go ahead, Ms. Love.
Thank you, Judge. Did Ms. Hilton attempt, or did she make any effort to explain perjury beyond what you just described for the court? Do you remember her doing that?
Doing this off the record or just in general?
In general?
Yes, she did.
Was the conversation that you are relating to the court that happened off the record, did it?
Shout out to Michelle Corley, my bad. Shout out to Michelle Corley. Appreciate you joining, family.
Refer to matters that you later discussed on the record as well, or not?
All of it, in a sense, was stuff that per se was explained on the record. It was just clarifying what would constitute perjury versus inconsistent statements, or whether she would need to impeach him.
Is that the type of conversation that took place off the record?
Objection, lady.
Sustained.
Yeah.
Sustained. Ask a different question.
Yes, John.
I don't remember if that was substance of the off the record. I do know during the course of the meeting, she repeated that several times, trying to explain the difference between purge and perjury.
And off the record, the comments that Ms. Hilton made regarding hypothetical instances where perjury could be occurring, did she clarify for Mr. Copeland in any way? Did she seek to clarify how she would be able to distinguish between perjury and something that wasn't perjury?
Objection, lady.
Overruled.
The off the record conversation was very brief and very short. And there wasn't a whole lot of explanations because that had already taken place.
The truth is that you are a liar.
If you've said, I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that's my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean with this part of it. Okay.
You're out here partying and running wild in the street, then you're just going to walk away and say you don't care?
I've never heard Mr. Copeland's in-court testimony about this and what that would be, but it's certainly not an admission by a party opponent that can be used against Mr. Stillwell, because there's nothing in here about Mr. Stillwell saying he did anything, and I don't know how. It's hearsay, and I don't know what exception this would fall under. I have a theory of what the state may argue, but It's not furthering anything. Except Mr. Mr. Copeland is apparently paranoid or whatever, and maybe he has some self-interest he's dealing with, but I'm not sure how it furthers anything. And so I don't want my client to be wrongfully linked to uncharged, well, I should say not substantively, and let me just say this too, no one's been charged with this act.
Okay.
It's listed as an overt act, but no one's been substantively charged with the actual crime. My speaker.
All right. So who all is
a little pokey as we're at the house and left? I'm just assuming from the way that he's speaking about it, and also this is partly it's the end of the day, but the court is correct that shortly thereafter, Mr. Copeland himself does state and says,
well, and I mean, if
I did it.
If Shannon, and I guess Lil Pokey is not anybody that strike that. If y'all want to say anything else after we get those, then I will entertain it. Okay. All right. So in the meantime, let's keep plodding through this set of statements of Mr. Zachary's.
Can I ask a date or a date certain for the court to inquire of a date certain on this issue before you?
On the debt, on the getting the affidavit and the search warrant?
No, on, I'm just, I'm sad saying it. I'm really hurt saying this, but this is not new. So a date when Ms. Love just said, oh, shoot, this is not a quote, but some effect of, oh, shoot.
That's a fact. Whitaker was for sure eating a gummy. CBD at minimum.
we must turn this over. That was before giving it to Agent Bernie. So what happened on that date of the oh shoot to we get it yesterday, and we don't get it like, oh, this is new stuff.
Good question. So we are one team, but we have many members and parts. But I will get the date. But I can tell you that when I said that there was the realization that
I have to reboot Miss Love. She be shutting down.
New stuff.
Good question. So we are one team, but we have many members and parts. But I will get the date. But I can tell you that when I said that
System rebooting. Please hold.
There was the realization that we do need to turn it over.
Yeah. When did that realization occur?
I will find out because it was not mine. It was not my realization.
Okay.
I'll find out. What I'm saying is,
who's in charge of the team?
I am. And so before it's mine, generally speaking, I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over. Collectively, we realized, oh my goodness, this has not been done.
The truth is that you are a liar.
Collectively, we realized, oh my goodness, this has not been done.
All right, and you don't know what date that happened?
No, that's what led to turning it over.
On Monday?
Yes, this weekend we were talking about it and we turned it over.
All right, so sometime over the weekend is when the realization occurred, oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over?
Oh my gosh, it has not been turned over and we need to turn it over.
Okay, and you're getting us the information about when we get the affidavit in support of the search warrant for the cell records, we'll know the date that occurred.
That is correct.
Uh-huh.
We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense?
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes. Right? I mean, obviously not, since you got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So, we weren't thinking along those lines then.
Okay. Have you at any point provided information that the phone number that y'all all know about from the affidavit and the nickname, which I think that's what it was. You were going to tell me what the nickname was, is actually DeMarco Boyer. Did you ever before Monday share that information?
No.
Okay. All right. What was the nickname?
Unk is
Unk?
the name that's listed on, I think, in the wiretap. I think it's
Okay.
Unk. That's more than one.
Power shutting
That's
down.
not uncommon. So I'm going to get all of them.
She losing power. Oh, system reboot. Reboot love again.
At this stage, which is mid-trial, anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
And that was sped up. That was her buffering sped up. It was actually slower than that. Look at her. Look. Hold on. Hold on. Hold on.
You know, you could get.
Hold on.
Anything else, whether Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
System rebooting.
You know, you could get criminally prosecuted. Let me be clear about this. You could be prosecuted by the district attorney.
And you may want to huddle with whomever comprises your team, and y'all all put heads together and really, really, really think about that, and then get me an answer after lunch, okay? Can you do that? Okay. Yeah, we'll recess in place until you come back from whatever you're going to find out at the door now. Thank you.
Sure.
A lot of the state's theory is that Mr. Williams is in charge of a gang and the gang does crime on his behalf. He asks for it and they do it. We deny that. I heard the court say and I heard the prosecutor say that this is inculpatory, no exculpatory. Everything could be inculpatory or exculpatory.
Okay. Can I just...
Of course.
I didn't say it's inculpatory. I don't know. Okay. I said the state, if I said that.
Love is a DEI hire.
I'm repeating the state's maintaining that it's only inculpatory.
I understand.
Okay, go
I
ahead.
appreciate it. And all I want to make the court aware as you go through decisions is if we knew about Mr. Boyer, then what I would have done is found out if he has a lawyer, because he's in custody, it sounds like, contact his lawyer, ask if I could go with the lawyer, and Miss Adams, when I say me, and Miss Adams, and an investigator, and interview him. And he may give information that's very hurtful to me. He may give information that is very beneficial to Mr. Williams. I don't know. My point is, though, that the state has no ability to know what's helpful or hurtful to Mr. Williams, and we have a right to investigate. So I just wanted that on the record as well, in case this goes up. Thank you.
I don't disagree. Thank you. I don't disagree. All right.
Real quick, y'all see up top, we going for a 3,000 subscriber sub goal. And do y'all know about an hour before I went live, I accidentally erased this whole video and almost had to cancel my show? So please hit the like button because I had to work hard to get it back, but I had to do some searching and I found it and got it back, and we here, family. So appreciate y'all being here, but for real, I erased this whole video trying to save it and was almost shut down. So definitely appreciate y'all being here. Help me hit that 3,000, hit that like, and let's keep it rolling, family.
Ms. Lev, if you're at a stage where you can shed any further light on anything, great. If not, we'll take it up after lunch.
I'd like to take it up after lunch if the court allow me.
I need this, Miss Love, assuming Mr. Copeland does not testify. What witness do you think we are going to be at by next Friday? Keeping in mind that y'all will be here at 8:45, the jury will be ready to go at 9, and we will work till at least 5:30 most days.
I'm going to.
With a break for lunch and a couple of bathroom breaks, and that's about it.
So, thinking, no further than, and when I say Agent Bernie, it's for these records that we have, not for the
Okay,
ones that
right, we talked about earlier, yeah.
But we will get no further than Agent Bernie.
Okay, all right, and so, will what you send in an hour cover at least through Agent Bernie with detail about what the evidence is going to be? Okay, all right. Okay, well, then we'll take it from there tomorrow. Let's be here at 8:45 tomorrow. And y'all think about the things that I asked you to think about and have some kind of proposal for me.
That we need to.
I tried to zoom in, but it's still too blurry to see it. Shout out to Steph JK with the super chat. I appreciate you, family. She say, love up in here in a kit. Like Stuttering Stanley. Shake my head. Sister Stuttering Stanley. Shout out to Steph JK. Appreciate the super chat, family.
Concern ourselves with right now.
He is Defendant Williams' nephew and someone that...
Okay, but he's not somebody on trial right
He's
now
not on
or
trial.
indicted?
He's not indicted.
Okay. All right. So I think it is fair to assume if Woody says, let's ride, and right after after Zachary said, here's the 3 people that I believe did it, and here's my reason for believing it. But in order, I think it potentially could be a statement if Mr. Stillwell shows back up with Mr. Copeland, and then Mr. Copeland's like, yeah, man, we did it. And Mr. Stillwell does not say, what are you talking about? I didn't do it. You might have done it, but don't count me in on that. Then that might be an admission because he's adopted it by silence. But not if he's not there when it gets said. So, if you can establish that when Woody says, yeah, man, we did it, that Shannon's standing right there with him, knowing there's $10,000, on his head, then yes. But otherwise, no.
Understood, Your Honor.
All right.
If you have something different, I have Detective Dennis says what he thought get you down there. What was Thug like? Zachary says he's normal. Detective Dennis says he doesn't give an F, and then Zachary says he's like, why the hell did they kill Nut? That's when I guess they told him. Nut said it's a go, and then he says Woody talking about Mr. Copeland is holding back stuff. He's kind of alluding to Mr. Copeland has friends. He knows a lot of people, so sometimes they're saying Mr. Copeland doesn't state everything with them. I'm
going to withdraw my objection.
Okay. And man, y'all weren't kidding about the transcription being less than 100% accurate. Okay. It is not this court reporter or my prior court reporter. I do not have any idea who this state used, but
maybe spares them on the record, Your Honor.
Like entirely off the record. Maybe next time y'all have a bunch of stuff transcribed, you give them like a list of key terms and names of people, and that would help them out a lot. Okay, anyway, totally irrelevant, but
shout out to Cat Not Williams. Oh, you had a hack and then you found the records? How you find the records after they got hacked? The paper files. That's what the papers say.
Okay, so
in light of my review of the transcripts, I'm going to withdraw my objection on number 18.
Also, okay.
Because I believe that, not saying it's the truth, but I believe Mr. Zachary was there.
Okay.
Questions, I believe, on cross-examination of Mr. Thomas kind of highlighting that Kevin Treadwell's wife is related to Donna Thomas. Because obviously that would cut, this is my idea of why defense would highlight that would cut against their family. Why would he be involved with the murder of his wife's brother? And so, but the state feels that discussing that because of some of that testimony, this isn't going to be a huge part of our direct questioning of Mr. Zachary, but that is another reason why it is more relevant than it may otherwise be that she didn't know. Zachary's saying she didn't know. Because obviously it would be very odd if she did.
Okay. So then most of 84 and 85 is admittedly not anything y'all would need?
Thank you, Loa.
Yes, Your Honor.
Okay. So then if it becomes, part of 85 and top of 86 becomes relevant, I mean, it's still like Zachary saying, I don't think she knew, right? I mean.
Yes, Your Honor, and I don't think we're going to be asking specific questions to try to, about this. It was the topic about, her it may never come up in our direct.
How about if you think it's going to, you raise it with me and we'll hash it out then?
Yes, Your Honor.
All right.
Mr. Treadwell's house or whatever it is on Oak Drive. I mean, he's clearly saying it's Bentley's spot in Oak Drive. Before we get to the part that I want to take out.
So do you just not want it said that he sells crack?
All the drugs. And this is why, Your Honor, Mr. Treadwell is not on Oak Drive. I mean, he's clearly saying it's Bentley's spot in Oak Drive. Before we get to the part that I want to take out.
So do you just not want it said that he sells crack?
All the drugs. And this is why, Your Honor.
All the drugs.
Mr. Treadwell is not indicted on this case.
Right.
Nothing involving Mr. Treadwell selling drugs is listed as an overt act at all in count 1. So we're just throwing in an associate.
Bubby, hey, shout out to Melissa. That's how I know you've been around. If you know Bubby, you got to be a real fan, a real subscriber if you know Bubby. Shout out to Melissa.
And there's no indication from this that Mr. Treadwell somehow kicks back money to Mr. Stillwell or Mr. Williams or anyone else. It's just Mr. Treadwell, who is associated with us through evidence that we know him. I think that evidence has come out that he's Mr. Williams' road manager at one point early in his career. But I don't know why we would get into his unrelated criminality.
All right. So if he's not an unindicted co-conspirator, if he's just an associate and there's no evidence that YSL is in any way benefiting from this guy Bentley selling drugs, seems like Mr. Schart's got a good argument here.
So, Your Honor, on the first point, and this was the act I was referencing, but just to give a little more clarity, there's individuals at a gas station, they think someone's trying to rob them because they're coming up close, and he calls Walter Murphy, who is a defendant who's pled, and Demise McMullen to come over and shoot with a stick, and they shoot and take off half of Dexter Montgomery's head. So Kevin Treadwell, he's the he.
Okay, Bentley, Kevin Treadwell is the one who makes the call, and then these alleged YSL gang members come to protect him and his drugs.
Yes, Your Honor, and that's in regards to him being like this, an associate, a member. The Detective Dennis in Gaither would classify Kevin Treadwell as a YSL gang member. Now, in regards to the drug proceeds, I do not have any evidence that, some receipt or some conversation of I'm paying my weekly dues to the YSL gang from this drugs that I sell at my trap spot. I don't have that kind of evidence. But the state, so I wanted to answer the court's question.
And in that incident, there was no evidence that these gentlemen were called to protect Mr. Treadwell's drugs. The state, I think, characterized it as just a senseless act. We were categorizing it as Mr. Treadwell believed that Mr. Montgomery and his associates were attempting to rob them outside of the gas station. But at that incident, there's nothing about drugs.
All right. Unless you got more than that, Mr. Atkins, I don't think that this particular part, which is 8325 through 8410, comes in.
One small request.
You may.
There's a part and I need to get the line of it where he says, Detective Gaither asked him, does he still drive that white Nitro? And Zachary says, nah, he let Nard F that up.
Okay.
I would like that part in because that white Nitro.
All right, that is not a part that is objected to, that's being excluded.
That's line 12 on page 84.
Thank you.
Are we completely abandoning for now the Zachary statements, or are we picking that up tomorrow?
No, I want to get through Zachary tomorrow and then move on to Sledge and then whatever else. But no, we're just abandoning that for now. It's time to go home.
Understood.
All right. Do we need an electronic?
Yes.
I can address, Mr. Sledge gave a prior statement that's can be played on evidence reviewer, following his arrest for the 2015 alleged shooting of houses. He was arrested as well as Mr. Zachary.
Okay.
I can address that. And there was one on what Mr. Adkins sent. There was one jail call that was identified, and I can address that as well. I don't know if there's more, but Mr. Sledge gave a prior statement that's can be played on evidence reviewer, following his arrest for the 2015 alleged shooting of houses. He was arrested as well as Mr. Zachary.
Okay.
I can address that. And there was one on what Mr. Adkins sent. There was one jail call that was identified, and I can address that as well. I don't know if there's more, but his statement I can address, the jail call I can address.
So those two, he's correct, identified those and given them to those. The statement is the statement we mentioned earlier. And the jail call is that Mr. Schardt is correct in those. And if we are ready to respond to whatever it is that they bring up while we're sending the rest of it.
Okay. The prior statement he made in 2015, he's brought in regarding the ag assaults, and he is questioned, he's Mirandized, he gives a statement, he denies any involvement. He later pleads guilty.
Okay.
Or offered, I'm not sure. He pleads somehow. He resolves it short of trial. He's just denying being there. So I don't know under what circumstances that statement would be used to impeach any testimony. I suppose he acknowledges that he knows Mr. Zachary. So I guess if he said he doesn't know Mr. Zachary, I guess that could be used to impeach him. But it doesn't seem to be a statement that would be used to impeach him or would necessarily be played. His jail call, I've listened to it. It's essentially him. He had a preliminary, he was charged with the murder of Donovan Thomas by Detective Thorpe. The state has since determined that he is not responsible. He had a prelim where no probable cause was found. After the prelim, he calls his significant other. I'm assuming it's his significant other. It sounds like it from the context. And he basically talks about the testimony at the prelim. He speculates about who witness 1, 2, and they used codes in the prelim, witness 1, witness 2, witness 3. He speculates about who that could be, and he basically says it sounds like witnesses 1, 2, or 3, and or some combination of within those 3 people really threw Shannon under the bus.
Okay.
So he's commenting, he's speculating, he's commenting about testimony he heard from a detective about what witnesses told the detective, and is just giving his commentary. It sounds like people really threw Shannon under the bus. I have no idea why anything from that phone call to his significant other would be admissible in this trial.
And Judge, the phone call would only be necessary if Mr. Sledge said something contrary to what he's indicating in the phone call. And I think a broader context, a broader sort of description of that phone call and what he says is necessary. So a few things are going on. Mr. Schardt is correct. There's a prelim. He's talking about stuff that has happened. What is most important in terms of the preliminary hearings are that Mr. Sledge is, he's privy to information that is given in other preliminary hearings of other YSL members. And he's aware that during his own, they are talking in terms of witness 1, witness 2, witness 3, rather than giving names.
Right.
What he says is, Lil D told, and Lil D is the witness that we've just finished listening to, Mr. Zachary. And he said, I can tell Lil D told because of, and he gives the information that was given by witness 1 or Lil D. He said, I can tell witness 1 is Lil D because he says this. So the fact that
The truth is that you are a liar.
it establishes, 1, the nature of you do not tell. 2, he has knowledge that people did tell, and he is not saying this didn't happen. He's not saying this person just flat out lied. There's no way. And it also explains indirectly why certain things may have happened. By certain things, this part is just an argument that would be made later. But if I were to make a statement in closing arguments that, of course, Mr. Zachary changed his story, everybody learned that he told, and he knew that everybody learned that he told, and now he's being looked at as a rat. So the call that Mr. Sledge makes and the content of that call are necessary for a number of reasons, and they become very relevant when put in the context of other evidence that we will be introducing at trial.
Okay. After I got you a mentor to spend some time with you, after I have pleaded with you to get your act together, you come in here, you cry, you carry on.
All right, anything else before we break for the evening? Yes, ma'am.
I want to get clarification on the timeline of the witness and exhibit list that state's supposed to turn into us, and whether you want our motions after they give it to us, or you want us to file it now.
What do you mean?
Because like my Jackson demo motion,
Yeah.
I filed it late because I didn't know until July 31st that they were going to use that interview.
I'm not sure, but okay. I mean, if that's what you say, great. You didn't know for certain, but I mean, Jackson Denos are normally a pretrial thing, and y'all can get with the state and ask them anytime. But as soon as you know that there might be an issue with something, and you know about it, you just go ahead and let me know. And if we get around to it, and the state says, we don't even want to use that because you haven't bothered to ask the state yet or for whatever reason, then we won't worry about it. But, yeah, don't wait. Don't wait. Go ahead and file everything. Everything should already have been filed. But, yeah, so on the timing.
I did ask the state, and they said they weren't going to use it.
All right. Well, we'll take that up next week. All right. I will see. Anything else? All right, I'll see all of y'all at 8:45 because inevitably there's something that we need to sort out or put on the record or something before the jury gets in. See y'all tomorrow. Thanks.
Shout out to Woody in the suit.
All right, it's Monday morning now, and I need to find out from you what your intention is with regard to whether you are going to testify in this case. You have been granted immunity so that the privilege of self-incrimination is no longer relevant because the state can't use anything that you might say in answer to their questions or any other questions against you. And you have been instructed.
What up, Indie Love 2008? I see you, family. Appreciate you joining.
With the benefit of counsel as to the consequences if you don't testify. So I'm asking you now what your intention is.
May I speak?
You can answer my question, please. And so you're under subpoena. The state intends to question you. Are you going to answer any of those questions? Are you going to testify in this case?
Well, Your Honor, I've been pressured from the get-go.
Yeah, your points keep adding up. As long as you come back, you still got points.
I mean, like, even when I went to the meeting with Glanville, I have told him over and over and over and over. You know what I mean? This is on my conscience. I got to keep distracting myself every day because I'm being dragged down into here because of lies that I don't told. I'm tired of y'all bothering me.
Okay, well, I'm sorry that you're tired of being bothered, but you're under subpoena. It's a valid court order. So your decision at this point is, yes, I will abide by the subpoena and testify, or no, I will not abide by the subpoena and the immunity order, and I will be held in contempt for my refusal and put in jail. So which is your decision?
But I did the time for all my crimes that I was caught for.
Sure, this would not be any kind of punishment for any crimes you may or may not have committed. This would be that you have been ordered by a court to testify, and if you refuse to testify, you're held in contempt. You're saying, I refuse to listen to the court's order and obey it. And it is not a punishment, it is an incentive to have you change your mind and obey the court order. So which is your decision?
Can you explain it to me?
So we talked about it.
It's the same thing that Glanville doing to me?
It is the same
Joel said,
order
I
that
felt like
is
it's-
still in control. You have a subpoena for, it is the same order that,
Thing that Glanville doing? Can you explain it to me?
so we talked about it.
It's the same thing that Glanville doing to me?
It is the same order that is still in control. You have a subpoena for your testimony. That is a court order. You also have a court order that says anything that you say can't be used against you other than if you get on the stand and lie and it amounts to perjury, you can be charged with that or with false statements. But if you refuse to testify altogether, when you're under a court order to do that, then that is considered contempt because you're saying, I don't care what the court has ordered, I'm not going to do it, and then you'll be put in jail through the end of this trial. Or until you decide, you know what, I think I will testify after all.
So, let me, Your Honor, I'm telling you to your face, you just said that something about it, they can lock me up for lying. I'm telling you to your face, this is all I do. And you're telling me that they can lock me up if I lie. But if I sit here and testify, so the E-way going to jail.
No, not with regard to anything that you might testify to that might otherwise admit to a crime or admit to your involvement in a crime. That's what the immunity order.
Y'all see what Steph say. The goal is 3K. So go grab your mama phone, your sister phone, auntie phone. Go grab your next door neighbor phone, whatever you got to do, and hit a subscribe and help us get to 3K. Appreciate y'all being here, family. We just about halfway through, and we still rocking and rolling. Let's go, fam. Hit the like, hit the subscribe, tap in, share with a friend.
Does, and I'm sure Mr. Melnick has explained this to you, and I know I've explained it previously, but none of that is going to result in you being put in jail because they cannot use that evidence against you to prove any of those crimes that you might incriminate yourself about. So are you going to testify or not? Do you want to talk to Mr. Melnick again? No? Okay.
All right.
Okay. All right, thank you. All right, so I'm going to have you step out for just a minute while we get the jury in. Mr. Melnick, if you could step out with him, please.
Hey, I thought I was tripping too, but I heard her voice pop up too. I don't know if it was from one of the clips or maybe I was watching her channel while I was recording something or I don't know what happened, but I did hear Cat Not Williams' voice pop up. Shout out to Cat.
Just so. Thank you. Yes, ma'am. I am. I was going to see if anybody had anything to say first.
Your Honor, I'm going to renew my motion for a mistrial based on coercion by Judge Glanville. This is based on the fact that Mr. Copeland, having now been properly instructed that he would only be incarcerated until the end of trial versus his instruction previously that he would be incarcerated forever. He's now deciding to testify. I think at this point it demonstrates the coercion by Judge Glanville, so I'd like you to reconsider that.
All right. I don't think it just demonstrates anything of the sort. I think it demonstrates that he's now been properly advised and he's making a decision anew. Thank you. Overruled. Yes.
Housekeeping matter. Is the Harvey rule still under your
Yes.
guidance? Still in
Yes.
effect? Okay.
Yes, it is.
Thank you.
Okay. And so I'm going to have the jury out. I'm going to give them the 3 instructions that we just discussed. Then we'll have Mr. Copeland in. I'd like him resworn. And then you can pick up from whatever you want to do post 3 p.m. June 12th.
And Your Honor, may I just step outside to see if Mr. Melnick has informed Mr. Copeland that there's going to be some testimony he's going to have to repeat. My interactions with Mr. Copeland, he'll get frustrated.
Okay, you know what? Why don't you, instead of you going to talk to anybody, just can I have Mr. Melnick in again? Yeah. Real fast. That's a good idea, though, to tell him that.
Kat says she in the system. Her voice is popping up everywhere. She part of the natural algorithm.
All right, Mr. Copeland, I'm going to remind you that you are still under oath. Go ahead, Ms. Hilton.
Thank you, Your Honor. Good morning. Mr. Copeland, do you know a person by the name of Shell Cow?
I don't recall.
Or say you don't recall if you know someone by the name of Shell Cow?
Sustain.
Do you recall speaking with law enforcement about an individual that you know by the name of Shell Cow?
I don't recall.
I want to go back to December of 2014 and into January of 2015. Were you present at a gambling house in Lakewood when the shooting occurred?
I don't recall.
Let me ask you. Also, back in 2015, do you remember being at a Cascade skating ring speaking with an individual by the name of Shell Cow?
I don't recall.
Back in January of 2015, do you recall being at a Club Crucial and getting into a fight with an individual by the name of Shell Cow?
I don't recall nothing that happened years ago.
All right. Do you recall in January of 2015 having to go to the Atlanta Police Department to talk about whether or not you were involved in the murder of an individual by the name of Donovan Thomas Jr.?
Say that again.
Do you recall in January of 2015 having to go to the Atlanta Police Department to speak about your potential involvement in the murder of Donovan Thomas Jr.?
I don't recall.
Right. On January 11th, 2015, did you go to the Atlanta Police Department at about 3 o'clock in the morning?
I don't recall.
Okay. And did you speak with a detective by the name of Detective Thorpe?
I don't recall who I speak with. I don't recall.
And during that interview, did you go down there to speak with him about the murder of Donovan Thomas Jr.?
I don't recall.
Hey, yo, shout out to FFS, now back again known as For Fuck's Sake. Hey, shout out to you, family. We appreciate the 10 memberships. Appreciate it, family. I'm going to have to add your name up top. As usual, always supporting. It's always much love. Via Steph JK, Steph FS. But shout out to For Fuck's Sake for the 10 gifted. If y'all got a membership, please say thank you. You're making it rain. That's right. Drop the rain emoji. We got a rain emoji now. Let me see. Appreciate you, family.
Who I spoke with.
Okay. And in that same interview, did you speak with him about not just the murder of Donovan Thomas, but events that led up to the murder of Donovan Thomas on June 10th, 2015?
I'm a liar. So you want me to remember something that I done lied about in the past? Like, I don't know.
So my question for you is, did you go to the Atlanta Police Department? Is your response you don't recall?
I don't recall.
And during that interview with Detective Thorpe at the Atlanta Police Department, did you provide him your name and your date of birth?
Huh?
When you went to the Atlanta Police Department and met with Detective Thorpe, did you give him your date of birth?
FFS said, I just made it sprinkle a little bit. Made it sprinkle. It ain't raining, but I made it sprinkle. Appreciate you, family.
I don't know.
Okay. And is your date of birth July 25th, 1991?
What?
Is your date of birth July 25th, 1991?
For fuck's sake, made it Deputy Sprinkle in this motherfucker.
I think.
Okay. And during this interview, did you tell Detective Thorpe that you also have a middle name of Xavier?
I don't know what I told. I don't remember what I told him. I'm not trying to say the wrong thing so y'all can lock me back up.
All right. Well, just bear with me. We're going to go through that interview, okay? Now,
disregard of the commentary by the witness.
Now, during the interview, did you speak with Detective Thorpe about the issues you had with a person by the name of Kel?
I don't recall.
And did you speak with Detective Thorpe about a problem that the two of you all had in the club?
I don't recall.
Okay. And did you tell Detective Thorpe in that same interview that Kel was Nut's little brother?
I don't know if they brothers or not.
Okay. So do you know who Kel is?
No, I don't recall.
Okay. And when I say Nut, is that Donovan Thomas Jr.?
You asking me that?
I am asking you that.
Say that again?
Sure. Do you know a person that goes by the name of Nut?
I don't recall.
Okay. Now, in that same interview, did you tell Detective Thorpe about you and Kel getting into the fight at Club Crucial?
I don't recall nothing from 2015, 14, 16, none of that.
Okay. And during that same interview, did you tell Detective Thorpe that you and Kel had been in a beef for maybe about no longer than 4 months? And this was back in 2015.
And he's still alive?
My question is, did you tell Detective Thorpe that you, Michelle Kel, at that time in 2015, had a beef, and it was probably going on around 4 months at that time?
I tell the detective whatever they want me to say, whatever they want to hear, whatever. So if I said it to him, I said it to him. I don't recall what I said to no police.
Okay. And during that same interview, did you tell Detective Thorpe that whenever y'all were in the club, y'all would initially just throw up birds at each other?
Huh?
In this January 11, 2000 interview, did you tell Detective Thorpe that initially, when you and Michelle Kel were in the club, y'all never really fist fought, y'all just would throw up birds at each other?
Like I told you, before y'all called me to trial, I have lied. I made things up. I told you this before y'all brought me in this courtroom. And I'm telling you now, you asked me about 2015, I have got my life together. Y'all trying to put this on my conscience. Y'all trying to put people's life in my hands. I don't lie on people. I don't want to be here. Y'all have pressured me. I'm tired of y'all, because y'all know y'all are wrong. And y'all black people doing this to us.
And I understand that.
Leave me alone. Let me leave. Man, y'all piss me off.
Leave me alone.
I don't recall nothing I said to no police. Stop asking me these questions.
Okay.
I'm telling you, I don't recall.
I understand, but we're going to have to get through the questions. You can just continue to say you don't recall if that's what it is.
That's what you want me to say?
I want you to
Hang on,
answer the
everybody,
question.
for just a minute. I don't think that you were instructing him how to testify. I hope not. But don't instruct him how to testify other than truthfully.
Thank you. And
Any other objection, or was that covered? All right, go ahead.
If you can answer the questions truthfully, and we can move forward. Can we do that?
I don't recall.
All right. Now, going back to 2015, did you tell Detective Thorpe first about a meeting that you had with Michelle Kel at the Cascade skating rink?
I don't recall.
Have you ever been to the Cascade skating rink?
I don't recall.
Is the Cascade skating rink in Atlanta?
I don't recall.
Did you tell Detective Thorpe that while at the Cascade skating ring that you met and that you talked to Michelle Kel about all the beef that you had with each other?
I don't talk. I'm gonna be doing with my gun.
Okay. Back in 2015, did you tell Detective Thorpe that you had a gun at the Cascade skating rink?
I would never tell the police nothing I did.
Okay. Now, back in 2015, did you meet with Atlanta Police Department detectives on at least 5 occasions after the murder of Nutt?
I met with them a lot of times.
Okay. And during each of those times, did you talk to them about what was happening between YSL and If Gang?
Nah, I was telling them whatever I think that get them off of me.
Okay. Did you go and talk to the police after your car was shot up on the highway?
It's called finessing.
Okay. But did your car get shot up while you were on the highway?
I don't recall.
Okay. Did you, your child, and your child's mother get shot at while you were leaving your home?
They got shot at.
Okay. Were you with them?
Not my kids and my child, mama.
Were you coming out of the house with you, your child, and your child's mother? Did that occur?
I don't recall.
Okay. Did your girlfriend's father's home get shot up after Donovan Thomas got murdered?
I don't recall.
So going back to January 11th interview with Detective Thorpe.
I don't recall.
Did you tell Detective Thorpe that you and Kel talked about the beef that the two of you had with each other?
I don't recall.
Okay. And during that, when you and Kel spoke, Kel asked you to call Thug on the telephone. It's an effect on the listener, I know.
It's a web.
Listen how dumb she sound. Talk about when you and Kel spoke. Like, them niggas was really on the phone. Like, yeah, hey, call Thug so we can squash this beef. She sound dumb even saying that in court. Appreciate y'all being here, family. Hit the like, hit the subscribe, tap in, share with a friend.
I'm sorry.
Effect on the listener, or not, whether or not he called, but what he did in response to being asked that.
All right. Overruled.
So, did you tell Detective Thorpe that when you met with Kel at the Cascade skating ring, he asked you to call Thug?
Okay, so this what happened.
Okay.
The police kept locking me up for whatever they could. Every time I came out the door, the police was on me. And they keep bringing up Thug's name. So what I did was, to get him off of me, I said, Thug did this, Thug did that, Thug did, because I knew they would never, I knew he didn't do it. And in my mind, I knew that the police would never go mess with him. So it was easy for me to try to throw the blame off on him to get them off of me. And that's what I was doing from all these years. I don't remember what I don't told them in the past. But my whole motive was, Thug did it because I knew he didn't do it, and they couldn't lock him up. And they keep talking about Thug, 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 Thug. So guess what I'm going to tell them? Yeah. What else you want me to tell them? Yeah, he killed this person? Yeah, he did that. That's what I'm going to do. And that's right now. If I walk out this thing and they say, the police stop me now. Hey, man, give me something about Thug. Shit, I'm about to make something up about him again.
On January 11, 2015, when you went to speak to the police, when they called you, did they ask you about Thug or did they ask you about the murder of Donovan Thomas?
I don't know. I don't remember.
Did you go down to the police department on your own to tell them that you did not kill Donovan Thomas?
Did I go on my own?
Did you walk into the police department by yourself to tell them on the morning of January 11, 2015, that you did not kill Donovan Thomas?
I don't recall.
Okay.
Do you recall your face being on the news that night and the detectives calling your cell phone telling you to bring your ass down here before you voluntarily walked into the police department?
So you don't recall going to the police, or you don't recall why?
I don't recall none of that. Right. I just know that every time the police was acting me, trying to get me, they kept bringing his name up. And I knew that they had me what I had, so I was like, yeah, whatever y'all want me to say, I would say it. And that's what I told Gaither and Dennis, and that's why they kept coming after me, because they felt like, okay, they can make a case out to him or whatever they trying to do. So they knew that, okay, we gonna get Woody today, he gonna have something to say about Thug, and it's wrong. And y'all are wrong because y'all know that I'm full of shit. And y'all keep trying to drag me in here to bring up bullshit that y'all know I don't say it. Why is y'all doing that? Leave me alone. If y'all gonna charge me for what I did, I don't did the time for the crimes y'all caught me for.
Okay. Would you mind your language while we're sitting here in court?
I'm trying to. Y'all need to give me a break because my blood pressure is real high. I keep telling y'all, leave me alone.
As much as love being there cussing, and even Hilton that same day reading them quotes, but y'all want to tell him mind his language, but y'all reading quotes and cussing all day. Y'all love those parts. Remember Sprinkle was like, I don't even remember the cuss word he said, but he sounded hella corny, but he was glad to say that.
Okay. And the quicker we get through this, the quicker we can leave you alone. Do you understand?
Okay,
that?
I don't recall.
Okay. Going back to January 11th, 2015.
I don't recall.
Can I finish the
Made
question?
him listen to the question first.
When you went to the Atlanta Police Department, Detective Thorpe didn't ask you about Thug. You brought up Thug. Do you recall that?
I did.
You did. Okay. So let's continue. During your meeting with Detective Thorpe, when you went down to the police department,
10 years ago, Everybody right here, take a break and think, what did you do last Thursday? Can you remember what you did last Thursday? Type in the chat what you did last Thursday.
Did you tell him about
Without no reference, don't look at no pictures, don't look at no forms, don't use nothing to remind your memory. Just think about it and type in the chat what you did last Thursday.
beef that you were having with Shell Cal?
Am I here to tell the truth or to remember my lies?
I want you to tell the truth.
But you keep going to my lies, though.
That's what you... Back in 2015, did you tell Detective Thor that this was a lie?
I would have told the police whatever. Listen, when they get me, I'm going to sit down and I'm going to try to tell them whatever I can to finesse my way out of whatever situation that I'm in.
Okay. And it's only now in 2024 that you're saying that everything you said in 2015 is a lie. Is that correct?
Because I went to the feds. Y'all didn't let me out of jail till what, four years later? So if I was telling the truth then, why it took y'all so many years to try to say, okay, he was being honest or whatever the case is? If I was telling the truth, y'all would have made any case back then. Y'all knew I was lying. Y'all put me in jail. I go do my time. I get out of jail, try to get my life together. Y'all trying to drag me back into the lies that I done made. Y'all, what's up?
Can I ask you this? In 2021, when you interviewed with Investigator Viverito after you got out of prison, did you tell her that everything you said back in 2015 was the truth, but we as a state didn't believe you back then?
So my thing is, right, I went to jail. So the lies that I was telling, they didn't go for it, y'all didn't go for it, whoever didn't go for it. So I went to jail, did my time for it, right? And then y'all got me again. So guess what?
Was we here Thursday? I think we was here. All right, well, what about Saturday? What about last Saturday?
Say, well, we're going to bring up the name again, and guess what I'm going to do? Try to finesse my way out of it again, because y'all ain't touching for the lies I done told on them in the past. So guess what? It ain't nothing to put the blame on Thug for what I did. And that's what I'm going to do. I'm going to blame him for...
And let me
I don't recall.
Okay, and let me ask you this. You keep talking about Thug, but were you asked about other individuals as well? During all these interviews, were you asked about Shannon?
And I'm going to put the blame on him.
Okay, were you asked about Demekion Garlington?
I'm going to put the blame on him.
Were you asked about Quindarius Zachary?
I'm going to put the blame on everybody but myself.
Okay. And during this time, did all the police, every time you spoke to someone, did they tell you that they are going to have to verify what you said?
And did they?
My question to
Copeland,
you,
answer the question that she asked you.
did they tell you that we had to verify everything that you said?
I don't recall.
Okay. And when they told you they had to verify what you said, you continued to talk to the police.
Because with the knowledge that I have, it's nothing to trick the police.
But if they had to verify what you said, they had to make sure that what you said was true. How could you trick the police?
Easy.
Overruled.
How could you trick the police?
Easy.
How?
I can't tell you that.
Were you aware
I ain't tell you that.
that the things that you talked about were verified?
That fake ass, how? And then she gonna say, are you aware that they were verified? Verified by who? Lion ass gator? Alligator with her lion ass, no reports, lion ass gator, that's who verified it? Get the fuck out of here. That's not verified. She didn't verify nothing. Except for that 8-inch in her pants.
Overruled.
How could you trick the police?
Easy.
How?
I can't tell you that.
Okay. Were you aware that the things that you talked about were verified?
Sustained. All right. We're going to take a quick break. Y'all all step back to the jury room for me. Thank you.
378 YD. And also that last question, we all heard this honorable court's statement that until a foundation is laid about asking Mrs. Zachary whether Mr. Williams, the answer was, I don't recall that ever happening, or I think he said no. I think actually Mr. Copeland said no, that did not happen. And then Ms. Hilton said, well, you told that to a detective. He said, I don't recall I lied to the detective, and then we just abandoned it and went to, I'm going to introduce June 10th. So that's why I've checked.
Ms. Hilton.
On the underlying foundation about whether or not he was aware that Mr. Williams purchased the gun, his response was, no, that didn't happen. And then I confronted him by saying, didn't you recall saying in this interview that you told the detectives that?
Yeah,
He said,
so
What up, Kristen Covey? I see you. Appreciate you joining, family.
you've established that it's a prior inconsistent statement, but what we were dealing with earlier when we were going through all of the statements is, does he even have any foundation to know that? And that was the foundational question, which doesn't appear to have been established.
so that's fine. We don't have to delay. We will extract those two portions out of the interview.
Okay, so you'll just take both of those out.
We'll take both of those out and we'll move forward with the rest of the interview.
All right.
Strike then, if you don't mind, the last question and answer, if the jurors can even remember what it was, without reminding them what it was.
Okay, well, we can strike it, but do you want me to do something to strike it, ask them to ignore it, or just move on? Sure.
I will have a response. I don't know if we need to strike because it's a proper question that I asked. He said, I don't recall it, and that's it. I don't know if there's a striking of a question because he did say that in the interview. That's not a improper question. And if he says, I don't recall.
Okay, well, the thing is, you're supposed to have a foundational basis to believe he might know. Let's just find out what, after consultation, Mr. Steele wants to know. Sure.
Same person who verified Quez. So who verified Mike then? I'm lost.
Yes, sir.
Thank you, Your Honor. Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor, gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people.
Shout out to TSC. Appreciate the gifted membership, family. Appreciate you being here. Much love.
That was premature because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is A-L-F-O-R-D.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this case. And yeah, it's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true.
So after this, Judge should have definitely been on her head. This is the part where it already went all bad. But right here, I think the judge, this is when she started turning her head against Love ass.
Even against this, I mean, he's saying he pled under Alford. And I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So Mr. Wright wants to share something.
Yeah,
Yes, sir.
I was waiting for the appropriate time that I was going to point out that it was in fact an Alford plea. So I thought her cross-examination information was not appropriate.
Well, y'all, I mean, maybe that,
He suggested
yeah,
it was something other than that. So,
well, maybe don't wait so long next time.
yes, yes.
But, I mean, I'm definitely going to, Ms. Love, do you want to be heard?
Yes, please. Go ahead. One, we
Quez verified Lil Mike and Squirrel Brain signed off. Shout out to FFS. Appreciate the super chat. Quez verified Lil Mike and Squirrel Brain signed off on it.
would ask that the court deny the motion for
Appreciate you,
mistrial.
family.
Number two, we would ask, as it relates to the assertion that no inconsistent statement was made, in the factual acknowledgments.
Okay, no, see, that's the deal with an Alfred plea, is you are not acknowledging that the facts are true, like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But you're not acknowledging on your own, yes, these are true.
Your Honor, when I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought you meant.
Within 444Y, we referenced this particular
All right, let's section. Maybe if you can point me specifically, let me pull that one up.
and fellow YSL associates, Demekion Garlington and Quindarius Zachary, committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in Sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction would be true for. But the factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
I just respectfully don't think that goes far enough. You know, you have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alfred. She elicits, and I'm not saying that she could have anticipated this.
She intentionally hiding shit. Way back, what was this, September 4th? A month ago? Shout out to Lee. Appreciate you joining, family.
But her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total confrontation clause violation. It's the second time.
All right, and that's Zachary and...
Well, Mr. Zachary, I anticipate may testify.
Right.
I don't know. He hasn't yet. But it definitely includes Mr. Garlington, who the state has said will not be testifying. And then, just for you to know, you were not here, but the predecessor judge permitted, over objection, the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alfred plea and said I'm specifically innocent.
Yep.
I mean, it was a farce.
Right.
And then the predecessor judge wouldn't even let me examine the witness, and Miss Love said that the witness I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no, and Mr. Steele is absolutely correct.
Have any intention of calling him?
Your Honor, no, and Mr. Steele is absolutely correct in terms, though the factual basis.
She said no, and he is absolutely correct. Stupid. Then she gonna argue still.
This is not in evidence. The fact of the shooting is not a prejudicial matter, which mandates a rebuke
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that that should go, but that was not something that I.
No, I know. I don't think that you intended to elicit that, but yes, I'm going to give a rebuke. Miss Love, I mean, that's just what it is sometimes to be the prosecutor in a case.
Smarter colleagues to give me some suggestions, which is everybody in these three tables.
NJB, Nay, what up? My bad, let me clear my throat. NJB, what up, family? I see you.
And Your Honor, I'm still reading under the annotations of that particular statute regarding the review.
We also presented this, by the way, as a guilty plea, not as an offered plea. And we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875, and I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters.
Facts at Berta. I don't know how they could keep getting away with it. Shout out to you for being here.
That I have just told you to disregard, and the state should not do that again.
Your Honor, what the annotations say is...
All right, Ms. Love, I'm going to give some sort of an admonishment, and I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it, so... I mean, I can grant a mistrial if you prefer.
Oh, no.
Okay, then maybe stop arguing at this point.
Yes, Your Honor.
Okay.
Your stupid ass.
Now, in terms of her having presented it as a guilty plea, an Alford plea is still a guilty plea, so I don't find there to be anything wrong with her having references in a guilty plea, but, we already talked about the whole factual basis thing, so I won't rehash that, but, okay. Mr. Harvey wants more. What else? I'll consider it.
You should be banned from asking any more questions ever for the rest of the.
Well, reasonably speaking, though.
That may be.
What did she say right there? I didn't hear her respond. He said she should be banned from asking any more questions for the rest of the trial. But I didn't hear what she said, though. What'd she say?
Going a little bit too far. You should be banned from asking any more questions ever for the rest of the.
Well, reasonably speaking, though.
Oh, she said for the rest of my life, or yeah, for the rest of your life, motherfucker. For the rest of your life, you should be banned.
That may be going a little bit too far, but that's already been asked for, by the way, and that the court, in giving these instructions, intends to rebuke the state for asking for eliciting that improper testimony.
So, Your Honor, it wasn't improper testimony.
Okay.
It was the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court if the court is going to read, that the court reads only what the court initially said.
I'm listening.
At the time he pled guilty in 2017, because
I understand.
Let me request that the court consider including in its admonition the following language, if the court deems it to be appropriate. Somewhere in there, the presentation of that evidence that I've described was improper and was not in keeping with the law and the prosecutor's ethical obligations. Accordingly, the state is admonished for their behavior and is instructed to refrain from asking or presenting any improper questions or evidence moving forward.
All right.
Evil also works perfect for love name because she asked backwards. So she backwards. So you got to read her name backwards anyway.
I'll do a little bit of it, but not all of it. What was that last sentence?
I like the first sentence.
I'm sure you do. Instructed to refrain from what?
Refrain from asking any improper questions or presenting improper evidence.
All right. Well, they're not presenting evidence, so.
And
right.
and should conduct themselves within their ethical obligations and
right.
legality.
Thank you. I'm not going to do that.
All right, I got some more.
Got some more? All right. I think this is going to be enough. All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you.
Yo, shout out to NJB Nene. As y'all know, we got a 3,000 subscriber goal, so please help us hit that. Appreciate y'all for being here, family. Hit the like, hit the sub. Let's go.
Just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But he, and we heard kind of a factual
Facts. Indy Love says, I had to sage my devices and TV after watching her. That's a fact.
Basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alford plea. It's just named after a case called Alford. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that.
Y'all saying Love be messing with the sniffing salts?
The facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard is, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alford plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to. He had no requirement to. He had no responsibility to, okay? So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial.
Yo, shout out to Elizabeth Wright with the 5 gifted. Appreciate you, family. If y'all got a gifted membership and welcome to the VIP, please say thank you to Elizabeth Wright. And real quick, before I go, I'm going to come back to that and leave it on the screen, but I want to hit this comment right here. FFS said, keep your nose clean, your powder dry. So if her powder not stepped on. Oh, man, she be messing with the sniffing salts. Oh, no, 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 no. But yeah, shout out to Elizabeth Wright with the 5 gifted. Appreciate you, family. Y'all show some love to Elizabeth Wright.
It's an Alfred plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that.
And real quick, how many times has she actually told him that? Could you imagine looking at they notebook? It's just like a bunch of pages scribbled out. They notes is all scribbled out and ripped out pages. Just disregard that. Scratch that. Never mind. I rebuked her. Rewind that. Appreciate y'all being here, family. Hit the like. Hit the subscribe. We trying to hit 3K. We on the way.
It had to do with that drive-by shooting guilty plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct.
I rebuke you, Miss Evil.
You to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to those curative instructions? All right.
Asistencia
All right, go ahead.
para Messi, 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 immens Messi, encara 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 Messi, gol, 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 gol.
Did you pass me this? Yeah, thank you. So there's a version, the final version of version 2, which was then changed to the final version of the plea agreement. And it says under number 8, the language, as we've already heard the state read about laying low, and then it says, and during the meeting, this is the meeting at the home, defendant, which would be Sledge, personally heard a YSL associate state, I caught that N nut down bad. Now, clearly, this is something that Mr. Sledge denied happened and has been taken out of the final plea agreement. But why? What my concern is exposing the jury to things that are not true.
So, yeah, I understand that. So I'm not sure exactly what Ms. Love's intention is with all of the different versions and whether she's going to ask that it be, that kind of detail come in, or whether it's just going to be, was there some additional quotation or something on there that then got removed? So, Ms. Love, can you shed some light on that?
Yes, Judge. As it relates to, I think I have asked Mr. Sledge, in fact, certain things, and the objection was that it was, of course, a document that wasn't in evidence, and I should not refer to it as a prior version, where I was trying to get him to compare one document to another. Right. So the intent here is to show the jury that changes were made at Mr. Sledge's request, and certain changes were not. And I just actually found, in response to questions from the defense about responses from Mr. Wright, and I just emailed it to them, an email from Mr. Wright to me on, from back then, it looks like December 27, 2022, where he's enumerating certain things and responding to it and making recommended changes. So there are certain things that I would agree just don't need to be said. They serve no purpose. And it would be just as beneficial and serve the same purpose to say number 8 is different and I took out certain things as it would to try and put in all that language. And that just doesn't seem necessary to put in that, some language that might be considered inflammatory, that the state thought was the case and they said no, it wasn't. Just the very fact that they had us take out language is what the state feels is important that the jury knows. Okay. So no, to the extent that, and if I don't think
I guess if you are going to tender that for admission, then that can be redacted and it can just show there was something in quotes that was then removed.
Yeah, I like that idea. And I'll, if necessary, I can really quickly go out and talk to Mr. Wright. But right now I don't expect to have him read certain things. And I know he's a lawyer, so he won't do it unless I tell him to. So I think that we're okay there.
Okay. All right. But was there anything else I'm sorry, did you have more?
I was just saying that, I was still sending them over the emails from Mr. Wright.
All right. Was there anything else in particular that you feel like if the particular document does come in, part of it needs to be redacted out?
I think we're all in agreement.
I just got an email, Your Honor, which has Brady material in it. Was just sent to us.
I haven't seen it. It didn't.
10 seconds ago. Yeah, it's interesting.
I don't have it yet.
Yeah, it's kind of coming through slowly. Some of us quicker than others, and I haven't it printed out. And I know we've got
more Brady material. September 9th. More Brady material.
a jury back there waiting, Judge. And I'm not trying to belabor anything, but this is trying to kind of handle this on the fly as we're getting emails.
I understand.
In the middle of this.
Okay. Sure, thanks.
And we're also having 8 copies sent over for the court and the defense and
So December 27th, 8:43 p.m. No, well, that was one version. We talked more in court, so obviously there were other versions.
I'm just wondering what I should be looking at when I am seeing what Mr. Wright's talking about.
So, if it's December 27th, 8:43, let's see, going back to December 27th to a December.
It's going to be
7th,
the 506.
It will have to be
452Y.
Yes, that looks right. That looks correct. And then December 20. But there.
Peace, family. I think Watch the Rise checked out, so I'm gonna have to manually operate y'all points. So appreciate y'all. Still, yeah, I can still use them. I still appreciate y'all. I just gotta manually hit it. There you go. There go the point system. We still in there. Let's go, family. Shout out to Watch the Rise.
There were other versions sent back as we talked more in court the next day, December 28th. So 453, 454.
Your Honor,
yes.
To answer your question, this email sent by Mr. Wright on the evening of December 27th would have been between the Sledge Agreement Updated and Sledge Agreement Updated 2.
Okay. All right, that's what I thought. And is the alleged Brady, what is that, item number 3? I haven't read it all yet.
Sir, I haven't either, but certainly number 3 is absolutely Brady. 4 as well.
He said it wasn't.
And it also obviously conflicts with what they kept as his factual acknowledgement, so it's clear that Mr. Wright was telling them that's not true, but it's still maintained, they still kept it as a factual acknowledgement.
Okay, well, this isn't actually saying that's not true.
Well,
it's saying the real issue was,
the factual
which he actually denied on the stand.
The factual acknowledgement says, while associated with YSL and to support and express loyalty to YSL, and then it says, and wherein on behalf of YSL, defendant threatened, and it all goes to intent and state of mind, and that's the important part of this case.
Mm-hmm.
No one's denying that the video was made, but what is the reason behind it? And from this email, Mr. Wright is clearly telling the state in an email on December 27th The video may have seemed like an issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl. That is Brady. That was never shared with us.
Okay, I'm not sure that that's Brady. I understand you to be saying that you think this is a denial of it being something done to support, and I don't know what the language was, support and whatever, the gang.
Your Honor, that's the crux of the case.
Yeah, no, I know. And a whole lot of this, y'all are going to have to ultimately argue to the jury your various sides, but.
Shout out to Lady Loves Life. I see you, family. Appreciate you being here.
For this to say, it seems the video may have seemed like the issue was gang related. The real issue was the girl that a member of a rival gang was then sleeping with, that was one of the alleged gang members' girlfriends. Might make that the real issue, but it doesn't necessarily make it in no way in support of the gang. And I mean, y'all can certainly argue that, but I don't think this is the kind of thing that is like, oh, this is, plus this wasn't the ultimate version, so I don't know what.
Hey, that's comedy.
Went back and forth after that. He ultimately signed with his attorneys, I don't know what the advice was, but knowledge, something that said whatever the ultimate number 3 was. And you know, y'all made and y'all have secured.
Destiny said we keep finding Brady everywhere, but Rico nowhere to be found. That's a fact.
Evidence from the witness that he feels like he was pressured and coerced into that, and reasons behind it. So y'all have an argument there too, but.
I think we've done a good job doing that, but we did all that without.
Right, I see it. I see you down there, Tall Glass. Your thoughts. You talking about what you thought? When your thoughts come into it, look at the facts. The facts do not agree with your thoughts. The math ain't mathing. Y'all all need to go back to law school.
The knowledge of this email, which should have been provided to us by the state. That's my only point.
And for what it's worth, the a significant portion of the state's questioning and then a redirect of Mr. Sledge focused around whether or not he had there were specific things that he had asked that they change. And so what we end up having here, what we know now from the email that we didn't have before, is that, again, going back to number 3, right? Number 3, as in its final form, talks about being associated with YSL, and talk about the video and where he's brandishing a weapon using a drive-by shooting to harm a person named Kayla, a rival gang member. But the state knew, certainly when they were redirecting Mr. Sledge a little while ago, that Mr. Sledge, through his attorney, had given them the information, had specifically denied that number 3 was accurate.
All right, y'all are saying had specifically denied, and I don't read it that clearly. I don't think that's a specific denial. That's more of like I'm clarifying that this is really more about the girl than anything else, which it frankly is. So, okay.
Shout out to NJB. You don't know about the 8-inch gator? That's because she keep that thing on her.
I mean, I hear what you're saying, but I don't read it that way.
If you look at number 4 also, Your Honor.
Okay.
Number 4 of the defendant's factual acknowledgments, and you got to excuse me because I'm kind of flying back and forth between the different versions.
Yeah, we all are.
But, number 4 talks about on April 28th, as reflected in the indictment, that the defendant and fellow YSL associate, Demekian Garlington, I'm just reading it into the record so I can perfect it, committed a drive-by shooting using the firearm defendant wielded in the video reference in part 3 of this section. So I'm looking at the email that we just received.
Right.
And it gives a whole total different accounting of that, where, and of course this is coming from Mr. Sledge because Mr. Wright says in his email, he said he didn't know because he was cool with Peanut, who was seeing his cousin, would even be at family reunions together. He thinks shooting Peanut was not planned, but more impromptu, or at least very short, or a little planning. He said he didn't know until after it was done when it came on the news. He had been watching the Patriots versus Steelers games with it, then the news reported it. So this again, and what you've got is the state directing and redirecting and challenging Mr. Sledge
on these very specific factual allegations and whether or not he had told his attorney that, or whether or not he had suggested that that be changed.
Shout out to Steph JK sprinkling another membership up in here. Y'all grab the umbrellas. If y'all a member, drop y'all umbrella emoji. Appreciate it, Steph JK.
The agreement, and what we have here, what we know now, is that Mr. Sledge was in fact sending those, correcting these very specific factual allegations, sending them to the state, and the state, well, because it doesn't appear in the factual acknowledgments, the state ignored it, or they refused to make it.
Okay, so I'm not sure what y'all are looking at, because the version of number 4, factual acknowledgement number 4, that Mr. Wright is speaking to in this email that he sent on December 27, 2022 at 8:43 p.m. is, we agreed, but at least Mr. Schardt and I agreed, was Sledge agreement, the one that is 452Y, from the one that's called Sledge Agreement. Well, there are two that are called Sledge Agreement Updated, but this is a correspondence between 452Y and 453Y, but ultimately the end product. After the one labeled Sledge Agreement Updated that came from 12/27 at 5:06 p.m. And that one reads, on January 10th, 2015, before the murder of Donovan Thomas Jr., defendant had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. Mr. Wright's response to that is essentially, Mr. Sledge does not think the shooting of Peanut was planned, but more impromptu, or at least very short or little planning. So that clearly got changed, because our final version doesn't say they were planning to. Yes.
May I incorporate? So I cross-examined Mr. Sledge, and the state's theory is that there was a, quote, gang war starting in approximately the fall of 2014.
Right.
That escalated with the fight on January 6, 2015 of Mr. Copeland at the Club Crucial. And then it culminated and then went on steroids thereafter, after January 10th. I would have used number 4 that you just read, Your Honor, to show that there was no animosity between Mr. Sledge, who's a supposed YSL member, and Mr. Donovan Thomas, who's a supposed leader of a, quote, rival gang. The reason I say this is because I knew about it. So listen, I want to make it clear. I knew about it because I spoke with Mr. Sledge through his lawyer. So I actually asked these questions.
Right.
I didn't know about this email. But
So
the email.
Go ahead, I'm sorry.
But no, don't apologize. But the email is Brady, because what the state was saying is these two divisions. I didn't put Mr. Sledge on YSL, and that there is a total collapse between human beings. And that, to me, I learned Brady to be anything.
It must be Brady's birthday. We having a Brady party up in this mug. Yo, shout out to Indy Love with the 5 gifted. Appreciate you, family. And Elizabeth Wright dropped another one. Let me see. Let me bring you up in here real quick. There we go. Shout out to Elizabeth Wright. Y'all show some love. Appreciate you, family. If y'all got a new membership, please say thank you to those two. But, yo, we having a Brady party tonight, huh? It's Brady all over the place. Anybody invite Rico?
That is potentially exculpatory or impeachment or mitigation. And the court has heard now, Mr. Copeland said I lied about everything. That to me is Brady. The statement on this number 4 is to me Brady, because it shows that there is not animosity.
All right. So your belief about the Brady is not the part that I was talking about, but more the part that says he here is Mr. Sledge, at least at the beginning. He said he did not know because he was cool with Peanut. He was seeing his cousin and would even be at family reunions together. Does the he change there, and is the he become somebody else was cool? Who is the he that was cool with Peanut? Do we even know? We don't.
I believe that is Mr. Sledge.
Okay. And so you think it's Brady material that Mr. Sledge was cool with Peanut?
Right, because Mr. Sledge is he's been identified before you came on the case, the bench, on this case, as from multiple to
definitely, maybe 3, supposed gang experts saying Mr. Sledge is part of this gang.
Yeah.
So to me, and it just fits into the whole, I thank you for allowing us to get these emails, but these emails there's a special duty here. And this is not the special duty, I don't believe.
Okay, so
I'd like to see all the emails from Mr.
I think she's looking and sending all that she has. Is that correct, Ms. Love?
2 things. Yes, and when the court permits me an opportunity to respond to all of this, I would appreciate that opportunity.
Okay, what was the second thing?
The second thing is I want to respond to all of this. Why is that even a thing? You already know I'm going to let you respond. Talk about 2 things.
Or 1 was yes, and 2, you want an opportunity to respond. Okay. All right. So Mr. Sledge has been available to the defense to speak to as well. We just heard that from Mr. Wright, in fact. And so I'm sure that Mr. Sledge, if asked, would have told anybody that asked, especially the defense, what his relationship and thoughts about Peanut were. So
He did, and I even asked him about it, and he answered similar to this.
Right.
But that really is besides the issue. The issue is that the prosecution has a duty. There's one thing. There's a Brady duty, and then there's a Brady violation. There's no violation because I knew about it, and it came out of court. But there is still the duty.
Okay, a Brady, I mean, we all know what Brady material is, I hope. And if something is equally available and as easily gotten by one side as the other, that sort of takes it out of the realm of Brady.
I don't agree with that respectfully, because what if I didn't do my job? It's an ineffective claim, and the state had the duty.
All right. Well, I don't.
You can't shun your duty and say, well, he has the Honorable Keith Adams, so he'll figure it out on his own. That's not. In fact, courts ask, this court, I believe, but other courts in this courthouse say, is there any Brady evidence known? Is there any evidence suppressible known by the state? And they give it to you, or they're supposed to. So I don't agree that, hey, go find it for yourself.
Well, I don't read that part of number 4 to be Brady. Yes.
May I respond to about number 3, though? I mean, the state provided us with a plea agreement with factual acknowledgments that appear on its face to be Mr. Sledge acknowledging certain things were done on behalf of YSL to further YSL. I don't have equal access to Miss Love's emails with Attorney Wright that she has. So clearly that email correspondence between Mr. Wright and Miss Love, which was never handed over until a few minutes ago, it contradicts and it impeaches those factual acknowledgments that Antonio Sledge signed. Now, I'd like to think that I do everything I can as a defense attorney, but I don't think it's unreasonable that a defense attorney would read the factual acknowledgments signed by a cooperating witness and accept that that is going to be their stance when they come and testify. And
well, lucky for y'all, it wasn't his stance.
Well, but I don't think that makes us getting it this last minute any less problematic.
Well, I'll just say that if the state has an open file, then none of these arguments ever even come up. Now, I know that that is something that y'all in your office can make a decision about, but open file would, just exactly what I said. So, okay, Ms. Love, what do you want to respond to? What do you feel like there still needs to be a response to?
Your Honor, I think that the court sort of encapsulated the position that I have pretty well. So you sort of took away the...
Shout out to Supreme L. Appreciate the super chat. This is to help find Rico. He hard to find like Waldo. Hey, we got Waldo up in here. Waldo is Mondo. We got Mondo up in here. I'll make a move for you so y'all can see him at the bottom. He hiding behind Finey right now, as usual. Waldo hiding behind Finey. I'll make a move at the bottom, though. Shout out to Supreme L for the super chat. Appreciate you, family.
Many of the responses that I had. And so, in as much as anything else that
Mr. Wright sent to me is being printed out. I think we have them all printed out. I'm going to send them over and disseminate to the counsel for the defense and to the court. Okay, thank you.
There you go. There go Mondo. Waldo.
Do I understand that to mean that there are more coming?
That sounds like it.
Oh, you better be glad I am a judge.
She has acted
You
like
better be
this her whole
glad
life.
I am a judge, because I will come down off this bench and I will kick your ass. I hate you.
All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement.
Just go ahead and scratch that one too. Y'all just rip that out your notebook or scratch it out, white it out, whatever you got to do. Just disregard that. Matter of fact, we're just going to give you a new book.
So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F 2nd 255. It's the 9th Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing: is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway.
So hold on. So with what she's doing, she wouldn't be able to retry the case anyway. So why is the case still going? Why have you not stopped the case if with what she's doing, she wouldn't be able to retry the case anyway? Stop. Think about it.
So Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
No, I don't know.
I
don't know what they think.
I think they winning the case. I think they winning the case. I might have to make a song out of that. I think they winning the case.
But I will say this. This is not becoming.
That the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
No, I don't know. I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time. It's
all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court, and I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said promoting statement is it's literally.
Oh, I saw that. I know.
I saw that. What up, Rainy Rain? Appreciate you being here, family. Y'all hit the like, hit the subscribe, tap in, share with a friend. We still rocking and rolling.
I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
It's renewed.
Thank you.
Yes.
Before I called Mr. Sprinkle when we intended to call Mr. Zachary, Mr. Sprinkle's testimony, and in order to avoid him being called twice, we were putting in the interview of Mr. Zachary, given his continued pronouncements regarding his health concerns and other considerations. We were going to call Detective Gaither to simply get in the interview regarding Mr. Zachary. Mr. Sprinkle's investigation, if you will deal with some of the information that comes from Mr. Zachary's interview. And rather than asking the court to call Mr. Sprinkle.
Basically, she's saying, I know I said we was going to do this, but you mind if we switch it up and change it up and switch the order up? I know it's out of order, but is it okay if I switch some stuff again because I'm so unorganized? That's what she said, translation.
Twice? Well, we're calling lots of witnesses twice, or you are calling lots of witnesses twice. So, Your Honor, I'd ask the court's permission, since we do have Detective Gaither here, to allow us to put in Mr. Zachary's interview and to allow us to.
Yeah, you could kind of curse, but still keep it, kind of moderated, because YouTube gonna block you if you cuss anyway. They block you automatically, but plus they restrict my videos when y'all cuss too. So try to keep it to a limit, or just disguise it. You know what I'm saying? Use emojis, use secret letters, block it out, whatever you gotta do. But we'll make it happen. And if it's funny, I'll read it out loud.
Proceed after
with no censor.
Detective Gaither with. And what is Detective Gaither just going to be introducing the interviews? She's going to be introducing the interviews. Primarily, that is the reason that we have her. She also confirmed, though Mr. Zachary was able to confirm some information about his phone number, another phone number. I told her that I don't expect to keep her very long. I don't expect her to be more than today, frankly. And yeah, that's it. And the other.
I have reviewed what the line of questioning was, and I do not think that there was anything nefarious and purposeful about trying to trick him into something other than what he'd been talking about. At the same time, I can see how it might have been, well, now, are you sure he knows that the people we were just asking about are the people that you're talking about, him now, coming to pick him up? So a valid objection, it remains sustained, but the motion for mistrial is denied. I am not giving any kind of instruction. You can just fix it by asking the next question. All right, anything else on that?
She said you could fix it by asking your next question.
Your Honor, just for the record. Okay.
Okay, and you use the mic too.
Yep, I understand. Yes, Your Honor, and I understand the court's ruling. I think that all of a sudden the use of they and those people instead of names, and then when asked for clarification, the refusal to do so, I think suggests that there was some calculation. But I understand the court's finding, but I would ask the court to instruct Ms. Love to clarify with the first question so everyone's on the same page, so there's not confusion amongst the jury, who he is referring to when he's talking about they in the car that night.
Yeah. Okay. Yes.
Go ahead.
Actually, Your Honor, I think the court was about to say something.
I think I was probably going to say maybe the same thing as you, but I have no idea. So go ahead.
I was going to ask that the court read back the exact question.
So look, that's the first time I caught her doing that. I was going to say maybe the same thing as you, but I don't know, so go ahead. So that makes sense that she did that. That's the proper way to do it and stop and not say nothing. Why are the judges always arguing for the prosecution? So then you making arguments that they wasn't. So Judge Whitaker said, hey, I was probably going to say the same thing as you, so go ahead. But watch the dumbass thing Love say. And it shows how different they arguments are. So they can't just be like, object, and you just sustain without listening to the argument, because her arguments be retarded. So you can't argue for Love, Judge. But this proves why right here. Listen to Love's response.
That I'd asked, and right before I said they.
I'll have to find it again.
So that wasn't what.
Go ahead.
Actually, Your Honor, I think the court was about to say something.
I think I was probably going to say maybe the same thing as you, but I have no idea. So go ahead.
I was going to ask that the court read back the exact question that I'd asked, and right before I said they.
I'll have to find it again.
So that wasn't what the court was going. So.
Stupid.
And obviously this is the real time. It's not the official transcript, but, you said you were close with Monktunk or cool with Monktunk. All right. Were you close with Monktunk in April 2015? Yes. Okay. And were you cooler with Monktunk than, say, Shannon? Yes. All right. Now in April 2015, were you also cooler with Garlington? And I can't tell what the rest of that is. Yes. April 28th, 2015. Do you remember being with those people? Yes. All right. Then I have to. Where? Back. Some kind of car. I can't tell exactly. I don't know what kind of car. What'd you have in the car? A gun? How many? 2 or 3? Yes, ma'am. Okay. And what time did y'all get in the car together? Daytime or nighttime? Nighttime. Was it after 10 o'clock? Yes. All right. I mean, at this point, there's nothing that indicates he doesn't think that we're talking about the 3 people that she just asked about.
The truth is that you are a liar.
Yes, gang?
Yes.
Is it a record label too?
I don't know.
Do you know whether Donovan Thomas was a member of it? You have to answer.
I'm thinking about it. I don't know.
Do you remember ever telling Detective Gaither and Detective Dennis in August that Donovan Thomas was a member of the gang?
I lied.
Now, you said that quickly. If you don't know or have to think about whether he was a member of that gang today, how can you
Because I'm
say-
pretty sure you're going to be asking me that I ain't said, so I lied.
Mr. Zachary?
I just answered your question.
To ask you to allow me to ask the questions and you answer them, okay? So, if you don't remember whether Donovan Thomas was a member of the F gang, how can you so quickly say today you lied when you said he was, if you told the police that?
Because if you said I told the police that, then I lied.
How do you know you lied if you don't know today that he was a member?
Because I just can't say nobody no member. You just told me that was the same thing with Tit.
Bentley, did you know Bentley having a spot on Cleveland, on Oak Drive?
Yes.
And where on Oak Drive was that?
I don't know. I just know it was on Oak.
How often, if at all, did you go there?
Every day.
How cool were you with Bentley in August of 2015?
Not at all.
So why did you go to his spot every day?
Because it wasn't necessarily his spot. Everybody just be on the street.
I'm sorry, what?
It wasn't necessarily his spot. Everybody just be on the same street.
Okay, so you did not go to his spot on Oak Drive every day?
I ain't go, like, everybody used to be outside.
Okay. Who is everybody?
The whole Mr. Cleveland Avenue.
Were there any people who weren't YSL out there?
I don't know who was that was out there.
You didn't see any people who were YSL who were out there?
No.
Do you know whether Duat was YSL?
Who was Duat? You gotta show me a picture. You said you gonna show me a picture.
Do you know whether Yak is YSL?
Yeah, I think he signed to him.
Do you know whether Shannon is YSL?
I never told y'all Shannon YSL.
I said, do you know whether he is?
No.
He is or is not?
He's not.
So, have you ever heard Shannon claim YSL?
No.
So, do you have to be signed to YSL to be YSL?
You gotta ask them that.
I'm asking you.
I don't know. I'm not YSL.
Then why you call yourself YSL Lil D?
I told you I was just really selling clothes and stuff. Like, I just wanted to be, I don't know. I just wanted to I changed my name there. Yes, I was a groupie. I was a fan. Yes.
Were you a fan in 2009?
Yes.
What was he doing that made you a fan?
He was rapping.
He said, I was a groupie. I was a fan. Yo, drop some sprinkle rain umbrellas. Elizabeth still making it rain up in here. Appreciate you, family, with another gifted. Appreciate you, Elizabeth Wright. Let's keep it rolling. He said, I was a fan. I was a groupie.
He was rapping.
Then why you call yourself YSL Lil D?
I told you I was just really selling clothes and stuff. Like, I just wanted to be, I don't know. I just wanted to I changed my name there. Yes, I was a groupie. I was a fan. Yes.
Were you a fan in 2009?
Yes.
What was he doing that made you a fan?
He was rapping. He was rapping.
Was he famous?
No.
Now, you're here in an orange jumpsuit. Why are you in an orange jumpsuit? Because the jury doesn't know.
Because you locked me up.
And why?
I don't know.
Were you subpoenaed to come to court?
I was subpoenaed. Then y'all told me I was on another subpoena up on the old judge. Y'all want me to volunteer to take a subpoena. What am I volunteer to take a subpoena for?
Did you tell your father to tell us you weren't going to come?
My father, he grown man. He tell you what he want to tell you. I ain't telling that.
Were you with him when he said you weren't going to come?
No.
Do you know whether he offered to call anybody?
You want to get my dad up here?
I want to talk to you.
Okay. I know you want to get him up here.
Why?
You know why.
Why?
You know why.
Tell the jury why.
You know why.
So you're not going to tell the jury? Was your father with you when you talked to Gaither and Dennis in August 2015?
No.
Did you live with your father in August 2015?
No.
Who did you live with in August 2015?
Myself.
Did you live with SG at any time?
Yes.
August 2015.
Yes.
Where did you all live?
I don't remember.
Were you coolest with Moontoon in April 2015?
April. Yes.
And were you cooler with Moontoon than you were, say, Shannon?
Yes.
Now, in April 2015, were you also cooler with Demikion?
Yes.
April 28th, 2015. Do you remember being with those people?
Yes.
Where?
Then we call our case. We was in the car together.
What kind of car?
I don't remember what kind of car.
What did you have in the car?
Gun.
How many?
So, 2, 3, 1 on.
And what time did you all get in the car together? Daytime or nighttime?
Night.
Was it after 10 o'clock at night?
Yes.
Had either you or either one of the people you were in the car with been to Club Usher?
I think they was.
So how did you end up in the car with them?
Came and got me.
Did you ask them to come get you?
Yes.
Why did you ask them to come get you?
Because somebody had shot up my cousin's house.
Where did your cousin live?
On County.
Right. And who is your cousin?
Alexis Bryant.
Why did you tell them to come get you if you had your own vehicle?
Because my girlfriend was in mine.
Your girlfriend was in yours?
Yes.
All right.
No, I'm wrong. Because I was going to get in the car with my girlfriend. I was getting dropped off to her.
Okay. And so, did you have guns?
Yes.
How many guns total were in the car?
I know I had 2.
And did you see any more?
Demikion had 1.
Were you wearing dreads during that time?
No.
Okay. So, where did they pick you up?
Hold on, pay attention. You see what she did, right? She trying to mix it and confuse and slide Shannon in there, but Shannon wasn't there. We just heard about that earlier from Moontoon, or before Moontoon, when they were saying him and them, and they shot up the house, but Shannon wasn't there. Where'd she get was y'all wearing dreads? Where's the paperwork that say anybody was wearing dreads? She trying to slide Shannon up in there. Shady movements. She slimy. Messy.
Where on Cleveland?
The store, I think.
Which store?
BP.
Was that the same one you were at with that gun?
Yes.
Where you got arrested in May?
Yes.
Okay. So, do you just normally hang out at the BP with guns?
Yes.
All right. So when they came and got you, what did they do? Your Honor? Yes.
Hey, I'm trying to figure out who we're talking about.
Your Honor, I, first of all, asked him about people, and I referred to those people specifically.
All right.
So,
Who are those people?
Your Honor, I'd ask Bill not to continue the question. He'll have no problem.
So is it a vagueness objection?
That's just Vegas.
Your Honor, I was specific. I asked him about a specific set of people.
I don't know
and
what-
I specifically referred to them.
Yeah, well,
Maybe.
we want to know who we're talking about.
Do you want to re-clarify, please?
I can continue, and then I can ask a separate set of questions. Of course, Mr. Schardt has him on cross.
Well, I think we should be clear about what we're talking about right now.
Ask.
Thank you. Go ahead and clarify.
When I asked you about Garlington, Monkton,
My bad, jumping too fast. I'm on mute. You see her? She's still trying to slide it in there. Like, if you being honest, why not just ask him who was driving the car? Why keep trying to disguise who was there?
and Shannon.
You said Garlington and Moontoon.
You didn't hear me say Shannon?
No.
Yes.
That
Let's take a
was to
break. Hang on. Let's just take our mid-afternoon break right now.
Right.
I mean, who was in the car, not who was driving the car, but still, same shit. Like, why is you hiding shit? If you a prosecutor, why are you hiding and sneaking? You supposed to be upholding the law, not breaking it. I can't even say it right because it ain't even a word. The law. Upholding the law. Joe bullshit.
Where he and his girlfriend lived. You said you were close with, and obviously this is the real time. It's not the official transcript, but you said you were close with Mungtunk or cool with Mungtunk. All right. Were you close with Mungtunk in April 2015? Yes. Okay. And were you cooler with Mungtunk than, say, Shannon? Yes.
What up, Nameless? Appreciate you being here. Hit the subscribe, hit the like. Appreciate y'all being here. Let me take a breath. That had me kind of hype right there.
All right. Now, in April 2015, were you also cooler with Garlington? And I can't tell what the rest of that is. Yes. April 28th, 2015. Do you remember being with those people? Yes. All right. Then I have to. Where? Back. Some kind of car. I can't tell exactly. I don't know what kind of car. What'd you have in the car? A gun? How many? 2 or 3? Yes, ma'am. Okay. And what time did y'all get in the car together? Daytime or nighttime? Nighttime. Was it after 10 o'clock? Yes. All right. I mean, at this point.
Yep. Recused Judge Whitaker. You welcome too. What up, family? I'm glad you was gifted a membership. Welcome to the VIP room.
There's nothing that indicates he doesn't think that we're talking about the 3 people that she just asked about.
Hold on. That's the whole point. That's the whole argument, is that it don't indicate the 3 people that you talked. Man, hold on. You got me confused. I can't even think straight. It got me so frustrated. Let me rewind that a little back. She twisting up the whole story. Hold up. Listen.
I don't know what kind of car. What'd you have in the car? A gun? How many? 2 or 3? Yes, ma'am. Okay. And what time did y'all get in the car together? Daytime or nighttime? Nighttime. Was it after 10 o'clock? Yes. All right. I mean, at this point, there's nothing that indicates he doesn't think that we're talking about the 3 people that she just asked about. Had either you or either one of the people you were in the car with been at Club Crucial earlier? I think they was. So how'd you end up in the car with them? And then the names don't always get.
So look, and then the names don't always get. So look, if she having this much problem reading the transcript, and then watch the lady, hold on, my bad. Let me move the smoke out her face. The court stenographer. Oh, let me move the smoke out her face. I don't want to disrespect her when I'm talking about her. Okay, so look, she gonna look back at her like, you know damn well you can read my writing. But why the judge acting like she can't read because she's skipping parts?
But somebody came to get you. Yes, all right. Why did you ask them to come get you? Because my head shot, and then something about where my cousin lived, Camp something or another, Campbellton. Why'd you tell them to come get you if you had your own vehicle? Because my girlfriend was in it. Your girlfriend was in yours. Yes. All right. I don't think, because I was going to get the car with the girlfriend, something. Did you have guns in the car? Blah, blah, blah. Were you wearing dreads at that time?
Blah,
no.
blah, blah.
Okay. So where did they pick you up from? Cleveland Avenue. Where on Cleveland? The store.
Look, then she reading the key parts. Did you have dreads at the time? Did anybody in there ever have dreads?
Think which store? Same one you were at with the gun? Do you normally hang out at the store with guns? Yes. All right. And he came and got you. What did they do? Your Honor, I'm going to object. So, I mean, again, valid objection, but also not, not any kind of purposeful, oh, aha. So
There's a live stream, and I reviewed the live stream. I'll also point out that nowhere in discovery, he says they were at the club, okay, in the testimony.
It would have been easier to review the live stream. Yep.
And Mr. Zachary said they were at the club.
Mm-hmm.
The state is very well aware, as am I, that even in prior statements, it is clear that, and Mr. Sledge's testimony, Mr. Sledge and Demekion Garlington were at the club. Mr. Stillwell is never alleged to be at the club, at Club Crucial. So it is very clear that Mr. Zachary is referring to, when he says they, is referring to Mr. Sledge and Mr. Garlington. It is also very clear to me by the fact that Ms. Love repeatedly refuses to clarify that she wants the...
Woo, shout out to Elizabeth real quick. I needed that because I'm sitting here clicking these chats and it's like my mind is boggling. I need to set this up here real quick. So I'm glad you came through. Appreciate you with the another gifted. Y'all drop some more rain emojis. Elizabeth making it rain all over the place. Appreciate you, family. I'm going to set this up here for a minute so I can stop clicking on these chats and get my mind to rest because they got me over here boiling. Let me hit this. Look, I even muted myself. Let me hit this spliff, and we're going to keep it going. Appreciate y'all, family. We almost up out of here. We got about 35, 45 more minutes.
Jury to believe that they also includes Mr. Stillwell, which is not what Mr. Zachary believes at this point. Okay. And I'm just going to ask that it be clarified with the first question, and then we can stop using pronouns.
We're not going to stop using pronouns. I mean, that's just not how people talk.
Well,
but
it's led to a mess.
She had already been instructed to clarify before we took the break, and she's going to clarify. And
Your Honor, I believe that Mr. Zachary already addressed that. The court can listen to the live stream or look at the transcript, but I think that I heard him say, because of Mr. Schart's, I don't know what that was, but Your Honor.
Yeah, he then said, I didn't hear you say Shannon. That's kind of how we left it.
And so, Your Honor, to the extent that there are these dispersions being cast, these I don't know, attempts for, I don't know.
Yeah, that needs to stop. I mean, you don't know what's in Miss Love's head. You don't know why she's asking a particular question. And, you know.
That needs to stop. What up, the D-Lifes? Jenny D. I see you, family. Appreciate you being here.
Just let's stop making it so personal between attorneys. That's really not appropriate. It's not professional.
Okay, well, Your Honor, I have strong feelings about what just happened, and I will stop saying what you don't want me to say, but I can't help how I feel about it, and that's not going to change. But I've also been accused of insinuated that I've been conspiring with a man that I've never spoken to in my life repeatedly, and
let's everybody stop with the personal jabs against each other. To the extent anybody has been making them.
What up, Nuts? I see you, family. I meant to say what up earlier. Appreciate y'all being here, family. Hit the like, hit the subscribe, tap in, share with a friend. We got some good stuff rocking and rolling tonight. We almost out of here. Much love to all the new members. Appreciate all y'all, family. Woosah, Tall Glass. I know, Tall Glass. I know it's tough, but woosah. Don't let them get you. Don't let you boil too hot. It's all happening for a reason. Just remember that.
Okay. All right. We don't need any more of this. Let's just get back on what we're doing. It's supposed to be based on facts. Okay. So you understand, if you're going to ask any more about this line of questioning, clarify who it is that you are asking him about.
Yes, Your Honor. I understand that if I'm going to ask him any more about this question, I'll clarify who I'm talking about.
So we'll get Mr. Zachary out, and I'll let him know that if he finishes today, he can go home, and that I don't quite know where he's going to go otherwise.
On what you just said about what I believe it was Miss Love asks about Mr. Zachary's father saying something, and she said earlier that it was said to Miss Love.
And Tall Glass, remember, feel free to express yourself. I'm not saying you can't speak your mind. Feel free to express yourself. Just don't let it burn your insides. Don't let them up under your skin. That's my whole thing. This is a place right here, though, that we can let go, have a little fun, enjoy ourselves. It ain't a funny situation, but it's a situation that needs some light, and we need some smiles in it. We got to bring some positivity to it. We can't just surround it with negative, or it's just gonna stay negative. We got to start bringing this positive energy to bring in the positive situation. You feel me? Appreciate y'all being here. Let's go. So that's why the smiles is helpful. It's gonna help with us laughing and smiling. We ain't laughing at them. Well, except for Love, but everybody else, we laughing with them. So appreciate y'all, family. Don't let them get up under y'all skin and boil y'all. Just know we here to make some changes. Appreciate y'all being here, family. Hit the like, hit the subscribe, tap in. Let's go. Brian Steele.
By the Father, that he has spoken with myself and Mr. Schardt. I'd ask that not be gone into, not only is it hearsay, but I don't know the evil or the benefit of doing that, because I've done nothing wrong at all, nor did Mr. Schardt. I'll vouch for him. The second thing is, Miss Love brought out from this witness that he purchased 2 or 3 guns from Arrowhead Pawn Shop.
Yeah.
One of those guns is found during the unlawful search of Mr. Williams' home on July 15, 2015. So I know I've done this. I know it's been ordered by the predecessor judge. I know it's been ordered by this court. I don't want to stand up and have to then say a mistrial and get a curative instruction if the mistrial is denied. That has to be just, in my opinion, just stayed away from the fact that that gun was found, or a gun was found in Mr. Williams' home. So I'm doing
May I
it now.
respond to that, please? Your Honor.
Yes.
Your Honor, with respect to the pertinent part, which is the part about the gun being found at Jeffrey Williams' home, and the assertion about the unlawfulness of the search, I won't even go back into that. But, Your Honor, as it pertains to who he gave those guns to, I believe that it is a valid question, and I will ask that the court instruct or allow me to speak to Mr. Zachary to tell him, don't say anything about where it's located, but I am going to ask him who he gave or who the guns were given to. The fact that it was found at Jeffrey Williams' home doesn't mean he gave it to Jeffrey Williams. And even if he did give it to Jeffrey Williams' home, that doesn't imply or speak to the search of Jeffrey Williams' home. So the state should not be precluded from putting before the jury the fact that Mr. Zachary purchased guns for other members of YSL, and that he told detectives that he purchased guns for other members of YSL. And
what happens next, and as long as you're...
Hold on real quick. You see his face looking at the camera? He was looking hot.
We finish your...
for other members of YSL. And
what happens next, and as long as we finish your testimony today, the direct and cross and whatever anybody of the attorneys wants to ask you, then yes, you can go home today.
What did I finish that?
If you don't finish, then we haven't quite worked out where you're going, but it will not be you're free to go, have a great life. It will not be Rice Street, but it will also not be bye, have a great life. It'll be something short of that, because you will, we'll just need to make sure that
Put me on house arrest. My grandma's funeral tomorrow.
we'll sort out. Your attorney and the state are working on potential conditions right now, so we'll sort that out.
What do you mean conditions?
I don't know what they're going to be. I mean, I may end up needing to impose them, but if they can work something out, then we're going to go with that. Also, when any of these attorneys is asking you a question, I want you to try to listen carefully to what specifically it is they're asking you, and then answer just that question, and you can explain it, but try not to just go off on something else entirely, okay? All right. Okay. Are we ready for the jury? Yes. All right. Let's get the jury out.
And jurors, thank you all for your patience when we have to take breaks. I appreciate that, as do the attorneys. All right, go ahead, Ms. Love.
Thank you, Mr. Zachary.
When just before we broke on the break, and you told the jury who you are saying today was in the car with you on April 28, 2015, who is it that you are saying now was in the car with you?
Me, Garlington, and Sledge.
Okay. You,
Garlington and
Garlington,
Sledge.
and Sledge?
Yeah.
All right. Today, is it your testimony that you three were the only people in that car?
Yes.
Okay. Now, you spoke about talking to detectives Gaither and Dennis back in August of 2015. Do you remember that?
Yes.
And before you spoke to them, you said that you had not spoken to them outside the room where you were interviewed, correct?
No.
Okay. No, you hadn't spoken with
No,
them.
I haven't.
Okay. So, had either one of them told you or given you any indication that they wanted you to do anything other than give them information that they could confirm or deny?
What you mean by that?
I'll change it. When you talked to...
Nope. Shout out to, let me see, that's kind of small. I can't see your name. Joni Ford. I believe he was not able to make it to his grandma's funeral. That's kind of messed up. They made him miss his grandma's funeral for this shit. And then gonna delay on all the other days. Like, wasting time, but then gonna rush me. Like, what kind of shit is that?
Detectives Gaither and Dennis, did they ask you about shootings that had happened in the city of Atlanta between January 10th, 2015 and the time that you were talking to them in August?
Yes.
I'm checking with the people that can control that part on our end in terms of sitting at the location. I'm trying to affect what the court is at.
Okay, well, I'm sure y'all will be able to do that. Y'all have been able to do things like that for years. So, Mr. Zachary, I am sorry that we were not able to finish with your testimony today. You saw the juror run out, and she had some sort of a sickness issue, and I think she threw up. And, having just come from the hospital, you probably understand. But she's too sick to continue today, and so we're going to have to pick up on Monday. And so what I think would be the best thing to do in the meantime is over the weekend to just put you up in a hotel room somewhere. You can, I know it's not awesome, but because.
Yo, appreciate you, Steph JK. We wrapping it up. We almost out of here. I know it's late on your side of town. We appreciate you, family. We almost up out of here.
There are certain members of your family who seem very determined to have you not finish testifying.
Oh, man. Huh?
Yeah. And I don't want there to be kind of...
If I ain't want to testify, I would sit in jail. Jail ain't letting me. I did 19 years.
So you'd rather go to jail than a hotel room?
I'm ready to go home.
I know you are. I know. But we're going to have you in a hotel room. You are welcome to have your mom or your sister there over the weekend. But I just think that it's better if it's a more controlled environment where your father is not going to be causing stress for any of y'all.
instead of his health or instead of his meds, she said his father should not be causing stress for any of y'all. What the hell? How the hell you gonna keep me in jail because you want my father not to cause stress for any of us? How do that make sense? The math ain't mathing. You ain't got the answer, Sway.
Okay.
My father don't cause stress with me. He cause stress with them. He supposed to do that.
I know. Well, I don't know that, but if he causes stress with them, then that might cause stress to you. So.
They took my phones. Can you tell them to get my phones back?
Which phones?
My
Just
phone?
for you to come testify?
I don't know. They took them.
Okay. Yeah.
No, the officer backed up took them.
I mean.
I think when they took him in custody.
They took both my cell phones.
I mean, I don't really.
They ain't turn them into property.
I don't really have a problem with him having his phones. The issue is him showing up for court. So it's fine with me if he gets his phones back. So is there anything else you wanted to let the court know?
Yeah. I don't want that lawyer no more.
You don't want that lawyer?
Why you working
anymore.
for them?
All right. Well, let me say this. When you come back,
I don't want that lawyer. He working for them. He trying to get me to agree with what they want. Not what's gonna help me. What's gonna help them? What kind of lawyer is that? That's the. All right. Let me stop before I boil my temperature.
on Monday, it may be that you want
no
a lawyer. You don't feel like you need any kind of lawyer whatsoever. So what if things change on Monday?
I don't need no lawyer.
All right. Well, Mr. Scheib, thank you for your service.
Yes, ma'am. Good luck.
Anything else? Hang on. I'm asking, actually, Mr. Zachary right now. Mr. Zachary, is there anything else that you need to...
I can go now?
No, because what's going to happen is that somebody probably from the DA's office is going to escort you to whichever hotel this is they end up putting...
Can it be her walking out the door?
Can it be what?
Oh, right, they're walking out the door.
I don't know whether it's going to be that particular investigator or not.
She know it.
It might be, it might not be. That one's not going to be up to me. All right, what else?
That's it.
Okay, so they will get you in not too much longer.
Okay.
All right. And we'll see you Monday.
Your Honor, at the risk of just generally being annoying, I would just ask that the witness and also both sides be instructed not to discuss the testimony over the weekend. I think that's very important.
So don't discuss what you've talked about before or what you might talk about later with anybody over the weekend. Just keep it in your own head, okay? All right.
Ooh, fuck nigga try me, I swear I got Lil Woody, pull up and pop at his noggin. Half time, half a perky, half a zone, nigga, half time, half a paper up, take my nigga, half time.
To address something?
Yeah, just briefly, Your Honor, and I'm not sure when the state plans on using this, but on the 27th of September, so 3 days ago, we got a Dropbox link with additional crime scene photos from a 2019 case,
Okay, don't forget it's a Brady party. They still got Brady rolling in. I'm behind on the chat, so I'm going to have to skip down to the bottom, but I appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Still bringing Brady in.
2014 case and a 2015 case. These hadn't previously been provided.
Of what?
Well, I think you'd have to ask maybe Mr. Atkins or the state. One of them relates to, I just have APD case numbers. I think they could give you more detail.
Okay.
My main point being these should have been provided in December of 22 at the latest. So I don't know why we're just receiving these now. And as seems to be my role in the case, I'm here to once again complain about late discovery, Your Honor.
Ms. Love?
Your Honor, I'd ask the court, since that is not something that will be broached this week at all, that the court allow us to address the matter when I have those files in front of me that Mr. Weinstein
How
is
about you get
referring
those
to.
files at lunch? Seems to me like
We
we're
can
going to
do
have a
that.
lot to talk about over lunch.
We can do that, Your Honor.
Oh, we can
And
do
also,
that.
I will say that those are, to the extent that, of course, I will look back and make sure that they were not previously provided, but to the extent that they were not, the crime scene information that we have turned over is a direct result of matters and witnesses that we have added back because of the objections that have been made. And the CAD reports, I believe, have already been admitted as evidence. So there is nothing about the photographs that would create any delay or prejudice or anything of that matter, but I'll address it at lunch.
What were the dates?
These are cases from, according to what Mr. Adkins sent, 2019, 2014, and 2015, Your Honor. And Mr. Adkins, in an email to me on that same date, the 27th, indicated to me that these had not previously been provided to us. So we can discuss it at lunch as the court wishes, Your Honor.
Okay. All right. Ms. Love, in your Sunday 6 p.m. email, you said that you were going to forward later in the evening to counsel and the court the portions of Mr. Zachary's interview that you were seeking reconsideration of based or because of, I guess, the way he testified. I'm not in receipt of that forward. Did you ever forward what the actual portions are?
Your Honor, I think, no, I forwarded the transcript, the corrected transcript that I was seeking.
But you didn't forward the portions that you had that either I had ruled out or you had agreed would be out?
I did not forward those. There were...
And yeah, that's what you expected everybody to argue this morning without even knowing what those were. Could you please forward those at your earliest convenience so that we will know by lunchtime what it is that we're talking about?
Absolutely.
Stupid.
Excuse me. I didn't receive the transcript last night.
Well, she's agreed that she's not going to be using the transcript because nobody's had a chance to look at it. So
Thank you, Your
you
Honor.
don't need to worry about that.
Thank you, Your Honor.
But I don't know if somebody's going to be over here to assist you later in the morning, but as soon as somebody gets here, you need to get that taken care of, okay?
Yes, Your Honor.
All right, so is Mr. Sprinkle out there ready?
He said that he needed 10 minutes from the time that I reached him, so...
Tell him, text him now and tell him he needs to get over here right now.
He is, Your Honor. He is coming. He
Text
literally...
him anyway and say the 10 minutes, he can't have any more time. He needs to stop what he's doing right now and come on. Because we have the jury waiting.
Yes, Your Honor.
And then while we wait, I guess you can go ahead and forward us those portions of the interview that you think need reconsideration, since we'll just be sitting here doing nothing otherwise.
Yes, Your Honor.
Thank you. All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing: is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know what they think, but I will say this. This is not becoming, in the state of Georgia, of a trial. And it is all the time, it's all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding walls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court, and I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said promoting statement is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
It's renewed.
Thank you.
Yes.
Much love, Steph JK. Appreciate you and all your support, family. Much love, much love. Shout out to Steph JK. Drop some green hearts in the chat.
Did not want to harm Mr. Stillwell specifically, but that's not my objection. My objection is she testified his intent was to come in and give truthful, to get himself out of trouble by giving truthful information that was absolutely improper, that was vouching for a witness, that was bolstering, and
Make sure you come back and watch the outro in the morning, Steph JK. You got to come back and finish. I need them 100% views. Nah, all love. Appreciate you, family. Green hearts, I see you.
and that is the basis for a mistrial. From an expert, I'll point out as well.
Your Honor, my response is that the court very well could and should instruct the jury that as to the witness's opinion about a interviewee's, well, first my response is we vehemently object to a mistrial. Secondly, the court could and should instruct the jury that a witness's opinion about another witness's statements or, testimony or anything that they said is not to be considered by the jury. The jury is the person that determines the credibility of the witnesses. And I can make certain that Sergeant Gaither knows when I'm asking regarding any indication that to not talk about truthfulness, but just to give objectively what indication or whether she considered that there was an indication. Secondly,
appreciate that, Steph. I see you, family. That's love right there. That's love. I appreciate you.
A mistrial is in no way warranted in this case when Sergeant Gaither did not say Quindary Zachary was being truthful. She said, I perceived. She said, I perceived. And that is why an instruction would be warranted that her opinion about his truthfulness is not to be considered by the jury. They make the determination about credibility. There is nothing about any of the exchange that just occurred that warrants or in any way justifies a mistrial. At best, an instruction is called for.
That I initially objected to the question to begin with, and I saw the danger, and the state insisted on asking that question that prompted this response. That was completely inappropriate.
All right, thank you. I'm going to instruct the witness as well. So we'll go ahead and take a break. And when we get back, I'm going to have the witness in and instruct her and then give an instruction to the jury. Going to deny the motion for mistrial.
Your Honor, I'd like to renew my motion for the next question.
All right, thank you. All right, we're on recess.
Assume we're all joined in that.
Yes.
Okay, thank you.
What length of time? 10 minutes?
I mean, yeah, 10 minutes. And by the way, that witness, Bernie, if he's not here already, he's on his way, the one who needed to testify in Cobb. So just in terms of scheduling, if y'all want to take him next, he's available. And I knew that we wouldn't be done with this Gaither anywhere near 10 a.m.
I won't feel offended.
Then I want to go back to the original question I asked about the allowing Mr. Copeland to speak with Mr. Garlington on a non-recorded line, okay?
I don't believe I stated.
I'm sorry to interrupt, Judge. May we approach briefly, please?
Yes.
I'm going to ask you to address the witness and speak to the witness, and also, quite frankly, to speak to the DA as well. Because of the way everyone is positioned, they're obviously closer to the jury than anybody else. Their microphones are live, and what they say can be picked up on a microphone. A couple of times.
Sorry, who? The state says at their table?
And what the witness is saying. And there have been at least 3 occasions where the witness has either before or after a question muttered something and said something into the microphone that can be picked up.
Well, I certainly haven't heard it. I can barely hear the answers.
I am not the only one who's heard it. At that last exchange, I heard her say something, I couldn't make out what she said, into the microphone. I guess she was frustrated after the question, and it's being picked up by the microphone. And if I can hear her muttering over here, whatever she's saying can be heard to the jury. And it's just inappropriate. I think it's simple enough to tell her to not make any extraneous comments that can possibly be picked up by the jury. Same thing for the state. And we've actually addressed this before prior to this court's involvement in the case, where there have been times where the state, either out of frustration or who knows why they're doing it, says something, or they're making faces and they're saying something that can be picked up by the microphone. And because they're that close to the jury, I'm sure the jury can hear it too. So I'm just asking, as I've asked before, and as they have been told before, to be mindful of the things that they say and the fact that it can be picked up by the jury.
I can't say that I heard this because I was in the middle of everything, but I've been told by multiple sources that once my cross-examination was finished and Mr. Steele was going to begin, the witness said horrible.
Horrible?
Horrible.
What? Okay.
And she's sitting right next to the jury.
If the witness and or the state is saying things like that and the jury hears them, I cannot imagine that reflects well on either of them.
Your Honor, I have to say, I would ask that presumptions based on assertions by counsel for opposing for the defendants not be taken as true and then spoken as if they are by this.
We heard it. We heard her all on the mic say horrible. And look at her always trying to fight, talk about somebody else. Oh, don't believe them. Don't take them as true. Because your ass sit there lying all day. So you feel like nobody should believe nobody. It's just like nobody. Why would you believe anybody? Everybody's lying. This is what we do. Why would you believe them? We heard her say horrible.
Honorable court, because I have no idea what Mr. Adams is talking about. I have not heard any mutterings. I don't know what Mr. Schardt is talking about. The state does not have the luxury to sit here and say what it believes someone from the defense is doing without it being cut off quickly. So I'd ask that the court not act on what is being asserted by counsel for the defendants as we stop these proceedings to address something nobody heard, but apparently Mr. Adams.
Fortunately,
and Mr. Schardt.
Fortunately, this trial is televised.
And Your Honor,
you know what? I'm going to stick with what I said before, which is if a witness wants to present themselves in that way in front of the jury, that is a reflection on that witness, and the jury can evaluate that. So, no, I'm not going to advise her or any other witness one way or, well, depends on what they say. And I didn't actually hear anything, but no, if she wants to make derogatory comments, then that is a poor reflection on her. And the jury, if they heard it, will notice it. And to the extent, I mean, I haven't, was that basically just about this witness?
It was about the witness and about the prosecution. And let's
Who's
be clear.
doing this, or you believe is doing something like this right now?
Yes, and who has done it before. I'm not just saying that. The court has addressed it before because it's happened before. So we're not making this up. She was admonished previously by the prior court to stop doing that.
And you're saying she's doing it again, and it is making faces and or comments.
Making faces, making comments. It can be picked up by the microphone. These mics are live. And as Mr. Schardt pointed out, luckily, this trial is being televised and live streamed.
I don't know why that's lucky, because the jury is not going to watch the live stream.
I'm not talking about I'm saying.
I mean, the jury is the one deciding this case.
The person making the complaint about the behavior is the defendants. And I'm in support of what I'm saying. I'm telling you that we are not the only ones who have noticed this. That's all I'm saying.
Okay. Well,
Your Honor, and I would ask, I have asked that the microphone not be close to counsel's table over here behind, so that.
Which microphone are y'all even talking about?
Anyone that can pick up
conversation at the state's table, because I'm not trying to have.
Those are not the microphones that's picking up, stupid. You sound dumb.
Our intro.
No, it shouldn't be. You all.
It's the mic that was on your hip that was picking up earlier. I forgot to add that clip, but I got that too. I'll pull that out later. It was your dumbass and Gator dumbass. She said that into the mic on purpose. She knew the mic was on.
Any attorneys ought to be able to talk to each other at their table privately without anything being picked up. So I don't know if that means y'all want to turn off your mic, because
that's how you know they go to the mistrial. They trying to get a mistrial. As hard as they can, they trying to get a mistrial.
we're in a big, awkward courtroom where nobody can hear anybody sometimes, but then apparently people can hear mutterings under the breath other times. So
we have it off. I've unhooked this, even though it was off. I don't want anything said at council table heard. Period.
Right. And then I don't know what the situation is with the mics that are on the back table, whether those are off.
No.
They're off.
Okay.
Sometimes what we learned the last time is that mic is on.
That mic being the podium mic, which has to be on.
So we have to be more conscious. Sometimes the podium mic can pick up our conversation because we're closest to.
Mr. Maurice has something to add, and maybe he knows because he's a media guy. Y'all, I guess because y'all are plugged straight into the system, y'all get to hear way more than we get to through the ambient air.
Something, and now you're nothing. I bet you wondering how fast things have changed. 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 You said I'm nothing, but now I'm something, and now you're nothing. I bet you wondering how fast things have changed. How fast things have changed. How fast things have changed. How fast things have changed.
Now I see you running, coming for my come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma. Now you wanna stay. Now you wanna stay.
So now I'm
stay.
Hey, appreciate y'all, family. Shout out to all the new members. Shout out to all the gifted. Hope y'all had a good time. It was crazy, man. They was wilding. I appreciate y'all being here, though. We had a lot of fun. I had a lot of fun. I thought I wasn't going to make it, but they can't stop me. They can't stop us. They keep trying to stop us every show, every time, but they can't stop us. No, but it's all love, man. I appreciate everybody here. I appreciate all the new members and everybody. I'm going to play this outro, and if it's anything you want to say, drop it in the chat. And much love to everybody, family.
No. Why didn't you, as an officer of this court, tell me? And that's not what the point is.
The point is, you as an advocate, is you should have told me. I got a problem with you now. I got a problem with you now. I would suggest you don't say any more. Now you want to have it both ways. You can't do it. Both sides have an equal responsibility under the rules of professional responsibility. All right, have a seat, sir. Thank you.
How fast things have changed. How fast things have changed. How fast things have changed.
Now I see you running, coming for my come up. Broke out all your shackles, turned it to some armor. Used to be the judge, but now you have no honor. To die with your pride is to live with all your karma. Now you understand. Now you understand.
Another night of fun. There's a lot of fun talking about. All right. Anybody else have any other issues as to?
Uh-oh. Fulton County has no problem coming in here and cuffing all of us, okay? Don't be an idiot.
Are you trying to tell me about myself? You homeless, and you don't even have a mirror to look at yourself.
Here. So I know you all about your principles. But can we just please just listen to Earl so we can get out of here? It's 4 cops on the other side of that door. You know if they come in here, they're gonna get your ass on a whole lot of other shit.
You lying ass bitch.
I knew it. Mama, I hate you, Will.
Don't you never come back to my house,
And
no.
I hope they blow your motherfucking ass to smithereens.
You better hope they do, bitch. You better hope they do.
This nigga kidnapped me.
I think I'm entitled. You want answers? I want the truth! You can't handle the truth! What are you, fucking nuts?
You thought?
All right, fam. We out. Much love to everybody. Thank you to the mods. Like you said right there. Shout out to Tall Glass. Shout out to Steph JK. Shout out to everybody who helped sponsor the stream. FFS. Shit, I can't see all the names, so I can't go through the names tonight right now, but I appreciate all y'all, family, and it's definitely appreciated. See y'all next time. My next show probably be Tuesday. I might start going Tuesdays, Thursdays, and Saturdays. So I don't know, but we see. Till next time, family. Peace out.